Hello, and welcome back to Tampa City Council. Roll call, please.
Carlson. Here. Hurtak. Clendenin.
Here.
Henderson.
Present.
Vieira. Miranda. And Maniscalco.
Here.
We have a physical quorum.
All right, may I have a motion to open the 1:30 public hearing? We have a motion from Councilmember Henderson. Do we have a second? Second from Councilmember Hurtak. All in favor? Aye. All right, these are quasi-judicial proceedings. We don't have anybody registered. If you're here to speak on item number 65, please stand, raise your right hand, and we will swear you in. If anybody is speaking on item 65, please stand, raise your right hand, and we'll swear you in. Okay, so we'll just,
I don't know if they're for this hearing.
all right. Let's just wait a minute then. Is it a lot of people?
No, two more?
Okay.
Looks like two more.
Okay. Yeah. Gonna get that fall feeling. I sleep with 77 and it's freezing.
Bus passes, free bus passes for families and students. This kind of questions I get.
Is that everybody? Okay. it's a new
Yeah,
era.
they were signing, I was on the elevator with them. Man, AOC is a magnet, you know. It's a magnet. I just wear it. And it's a finger puppet, but it's a magnet.
Yeah, let's just swear in the folks that are here. Please raise your right hand, we'll swear you in. She counts too. Oh, okay. All right, well, we swore in the folks that are here, so.
So there's another, one more left.
One more, okay. Sorry, thank you for your patience. All right, if you were not sworn in 30 seconds ago, please stand, raise your right hand, and we'll swear you in if you're going to be speaking on item number 65.
Do you swear or affirm that the testimony that you're about to provide is the truth and nothing but the truth?
Thank you very much. We will begin this hearing. Yes, ma'am, Ms. Johnson-Velez.
Good afternoon, and thank you, Mr. Chair and members of City Council. Susan Johnson-Velez with the Legal Department. This item number 65 is an alcoholic beverage license suspension hearing for the property located at 7700 Courtney Campbell Causeway, which is currently operating as an establishment called Godfrey Hotel and Cabanas. We do have kind of a site map here, if I could get the overhead. If I could get the overhead.
Yes, there you go.
Thank you, okay. So this is the site out here outlined in red. You can see it's a little peninsula that's on the southern side of the Courtney Campbell Causeway. To the east of the site, we have some office and commercial uses and some residential here. We also have hotel and office and commercial on the north side of Courtney Campbell directly opposite, as well as some residential. There's some restaurants in here, Bahama Breeze is back in here, and then we have more single-family residential to the north and going into Hillsborough County. So this parcel located at 7700 Courtney Campbell Causeway has been owned by M2 Tampa LLC since August 11th of 2021. That ownership information can be found in the binders I have provided to council in section B at tab 2. Since that time, M2 Tampa LLC has operated an establishment called the Godfrey Hotel and Cabanas, and the hotel includes a restaurant called, we call it Water, but it's really WTR. There are several permits that are relevant to this site. There is, from the city, ordinance number 5886-A that was passed and adopted on March 18th, 1974. So it's a 50-year-old permit that approved the sale of beer, wine, and liquor for COP for consumption on and off the premises. And so because of the age of this permit, and council is aware that we don't really wet zone properties like this anymore, but this alcoholic beverage wet zoning covers the entire parcel. So the buildings, the pool, the restaurant, the parking lot, it's the entire parcel that this permit covers. So there were no limitations or conditions that were placed on this approval back in 1974. Then next we have ordinance number 2007-136, which was passed and adopted by City Council on June 28th of 2007. That ordinance approved a PD rezoning on the property, which, as you know, is a planned development, and it approved hotel, commercial, and residential uses. You have a copy of the notice of intent to seek suspension of this alcoholic beverage permit in your binders, and that ordinance, well, the first ordinance that I spoke about, 58886A, is Exhibit A to the notice of intent, and ordinance number 2007-136 is Exhibit B to the notice of intent. So that ordinance did place limitations and conditions on the approval. The rezoning was for the property described in the legal description, which is, again, the entirety of the property. The ordinance limited the rezoning to the site development plan that was dated June 4th of 2007. A copy of the site plan is attached to that ordinance as Exhibit B. And then in 2017, there was a request by the then owner to do a substantial change or a non-substantial change to this site plan. So, and that was substantial change application number 17-23. So that request was approved by the then zoning administrator, Gloria Moretta, on July 17th of 2017. And that sub-change approval is attached to the notice of intent as Exhibit C. So pursuant to that request, the zoning administrator determined that the proposed change was not a substantial change pursuant to City of Tampa Code, and she conditionally approved the site plan that showed renovations to the outdoor activity area at the northwest corner of the property. So that would be in this area right here that's adjacent to the water. So the renovations were to remove 2 kiosks, remove the existing volleyball court, stage and shed, construct a new pool, construct cabanas, all of which were to comply with rear and front property setback lines. Proposed to place a new shade structure west of the restaurant building and to expand the bathrooms. So Ms. Moretta did impose a number of conditions on that approval. One was to remove the small pool. The second condition related to solid waste and stormwater, which aren't really relevant to this, but that was a condition as well. All the renovations had to comply with the fire codes. And then the condition that is important and germane to this matter is condition number 4. It says, prior to a temporary special events conducted on the property, the proposed special event must be reviewed and approved by the Land Development Coordination Division and be subject to compliance with Section 282.16 as may be amended. So this is the code section that governs temporary special events. It limits the maximum duration for a specific event to 2 weeks, and it also limits the number of events that can be held to 4 per year on any single piece of property. If tents or outdoor displays are going to be used, you have to submit a site plan. You have to show that you're providing adequate parking. You have to demonstrate that you have adequate bathroom facilities, and you must clear all trash and debris from the property immediately after the special event is concluded. So as part of that substantial change approval, there was a site plan that was approved, and those notes that I just read off are included on the left side of this, and you can see, I'll just zoom in just for a quick minute, but you can see their number 4 is the language that I just read off prior to a temporary special event, and then the things that have to be shown. Also importantly, the notations on the, were added to the right-hand side of the site plan, and here the one that's important is the note number 1 that says, no ticketed outdoor concerts except to the extent that the owner files an application and receives permission for a special event on the property pursuant to Section 282.16. And so that was part of the conditions of approval. So those are the 3 city approvals, permits that are on this property. M2 Tampa, through a related entity, also has a state alcoholic beverage license. That license is issued to M2 Tampa Tenant LLC, and they have a retail beverage license number BEV 3911078, which is a 4 COP license, which corresponds to the wet zoning that's on this property. That state license was issued on August 11th, 2021. It is current and active, and it expires on September 30th of 2024. And that, if you would like to just take a peek at that, can be found at Section B in tab 4 of your binders. So we're here today pursuant to a notice of intent to suspend alcoholic beverage sales at this location, and pursuant to Land Development Code Section 27318. That's the section that governs alcoholic beverage permit suspensions and authorizes the revocation or suspension of alcoholic beverages for cause. And that code section can be found in Section A at tab 1. So under 27-318, subsection C, which can be found at page 3 of that section in your binders, in order for the city to suspend or revoke an alcoholic beverage license, it must determine that the property owner, the holder of the alcoholic beverage license, the operator of the establishment, or any agent or employee thereof have been found to have violated or been convicted of any one or more of 14 qualifying criteria that are listed in subsections A through N. And again, that laundry list can be found in Section A under tab 1 at pages 4 and 5. I'm sorry, at page 4. So the focus and basis of today's hearing are violations of subsections D, L, and N of section 27-318 C1. So D speaks to the operation of the establishment in a manner that repeatedly or on an ongoing basis has negative secondary effects on surrounding property. This includes but is not limited to violations of city code, ordinance, or state law related to noise, parking, or trash and debris after having received reasonable notice to terminate or correct any condition that is in violation of such code, ordinance, or law. So that's subsection D. Subsection L, been convicted of the exterior maximum sound levels as provided for in Chapter 14, noise. And then finally, subsection N, violated any section of Chapter 14 or Chapter 27, any condition, limitation, or restriction imposed by the City Council or the zoning administrator at the time of approval, or any other section of the City of Tampa Code relating to alcoholic beverages. So this afternoon, we will present evidence and testimony that the property owner has indeed violated those three subsections of 27-318 C1. Now, I just want to speak for a moment on notice, just to confirm that the city has complied with the notice requirements. There are notice requirements in 27-318 found at subsection D, that prior to suspending an AB permit, council must hold a public hearing, and notice of the hearing must be sent via certified mail to both the property owner and the business owner at least 30 days prior to the hearing. And so the city complied with those notice requirements by sending a notice of this hearing on June 28th, 2024. So I'd like to start out with, I kind of want to go backwards. So we'll start with number N, which is, again, the violation of Chapter 14 or Chapter 27. And for that purpose, I'd like to call Eric Cotton, who is the city's current zoning administrator, to come forward to testify about compliance with the conditions of the city's prior approvals.
Good afternoon, Council. Eric Cotton, Development Coordination. I have been sworn. Just to parrot on some of what Susan just indicated, again, this was an ordinance, it's an older ordinance adopted in 1974. As Susan indicated, the prior ordinances, when they were adopted by council, generally covered the entire parcel. So this is a wet zone from property line to property line. I'm not going to go back into the sub-change, but the key to the substantial change issue that has brought us before council today is the requirement for the applicant to get a temporary special event when they have an outdoor ticketed event. So the language, Susan showed that on the Elmo just a moment ago. So the applicant actually has applied for some special events. So in December of 2021, I issued a letter to the property owner letting them know that they might be in possible violation of their substantial change and therefore their alcohol by not getting the temporary special events. So in December of 2021, they did apply for a temporary special event for their New Year's Eve party. They then applied for another special event for another New Year's Eve party in 2024, and they've had subsequent 2 more temporary special events they've applied for and have received. That's not to say they haven't had other events on the property, but they have sought out at least 4 temporary special events since the letter I sent on December 2021. That's real.
So, subsequent to that letter, as Mr. Cotton just testified, there have been actually temporary special event applications that have been submitted pursuant to the conditions. But we're here today because there are a number of events that have happened where the owner has not sought a temporary special event permit, which is contrary to the conditions of their substantial change approval and those conditions. So we do have, there are 3 code enforcement cases that, where orders have been issued based on violations of those conditions. So we have, the first one was, let me zoom back out. So this is case number COD 21-4580. You can see here I've highlighted, this was an order that was issued by the Code Enforcement Special Master to M2 Tampa LLC. Code Enforcement Special Master found that between December 19th, 2021 and January 5th, 2022, the property located at 1700 Courtney Campbell Causeway was in violation of Tampa City Code. That violation was of section 27282.16, the temporary special event permit. And you can see at the bottom the highlighted language. Code Enforcement Special Master found that this was an irreversible violation, incapable of correction, because it was an event that had already happened, so there was nothing to do to correct that. And there's a notation here in all caps: the property must comply with its PD and remain in compliance going forward by continuing to obtain temporary special event permits for all future outdoor ticketed events. And then the Special Master imposed a $1,500 fine for those violations. Later on in 2022, there were 2 more cases. The first one was COD 22-2075. Order was issued on October 24th of 2022. That order again found M2 Tampa LLC in violation of City of Tampa Code for events that took place between May 14th, 2022 and October 19th, 2022 at 1700 Courtney Campbell Causeway. And again, this was for failure to comply. Again, the citations or the code citations are listed here. Again, we see failure to comply with 27282.16, the temporary special events. The Code Enforcement Special Master found that ticketed outdoor concerts have occurred on the property and future outdoor ticketed concerts are being promoted. Per the approved substantial change conditions, the property owner has failed to obtain the necessary temporary special event permits, and they were ordered to cease all temporary special events until they make application and get approval for those events from the Development Coordination Office. Again, the finding was that this violation was irreparable, and so the Special Master, pursuant to his authority, ordered a fine of $15,000 in that case. And then the third case, also heard on the same day, was for a different event. So these are 3 different events that these 3 separate orders are now based on. So there's another event for case number 22-2076. That was for an event that happened between May 15th, 2022 and October 19th, 2022, again at 7700 West Courtney Campbell Causeway. Findings of fact were that M2 Tampa LLC was again in violation of the City of Tampa Code. And again, we can see the citation to section 27282.16, temporary special events. And you can see the same language there was reiterated in this order as in the prior one that was just displayed, that they have ticketed outdoor concerts, they continue to have them, and they continue to promote them on the property without getting the proper temporary special event permit. Again, the special magistrate in its order repeated that each temporary special event must have an approved permit, that you can only have 4 per year, and that the finding again that the violation was irreparable and incapable of correction, and again imposed a $15,000 fine. So now we have total fines in the amount of $31,500 And that was back in October of 2022. So here we are, almost in October of 2024, and these events have continued to occur without obtaining the proper permits. So that's the one basis. So this property owner has failed to comply with the conditions of approval of their zoning, as well as their substantial change in that they have previously failed to obtain temporary special event permits and continue to not obtain those permits. So that's the first basis under subsection N. The second basis, conviction of the exterior maximum sound levels as provided for in Chapter 14 noise. So back in April 30th of 2023, there was a citation issued to Joshua Hughes at 7700 Courtney Campbell Causeway. You can see the address right here. And the charge was unreasonably excessive noise from a property after warning, and the property not being in Ybor or the Channel District. So council will recall that in Ybor and the Channel District, we measure noise by a decibel level, but every other place in the city it's measured on a plainly audible standard. So this officer went some distance away from the water restaurant that's located on this property, and you can see where I've highlighted that the officer measured from water to where the officer heard music at Bahama Breeze parking lot, which was 2,630 feet away, on the other side of the Courtney Campbell Causeway. So just for reference for those of you who don't frequent that area, I have again the property highlighted in red, and then Bahama Breeze is over here with the pin mark where my pen is pointing right now. This case went to trial, or was prosecuted under, in Hillsborough County Court under case number 23-IN-001189-A. Went to trial on January 8th of 2024, and Mr. Hughes was tried and found guilty by a jury or by the court for a violation of section 14-154A, unreasonably excessive noise from a property after warning. And Mr. Hughes was ordered to pay a fine in the amount of $238. So that's the second basis, conviction of the maximum exterior sound levels as provided in Chapter 14 noise. And so I know we have a number of residents who live in the area, and I would like to, with council's permission, to have them come forward now because they can provide testimony relative to the third basis for this notice of intent, which is negative secondary effects on surrounding property. I believe, I know that there's Ms. Roberts here, I believe, at least, and I would ask you to come forward, and then maybe everyone else can line up on the side to be heard by council.
Would this be a part of
The
the public
city's,
comment? Would they
this
be
is the part of the
case?
city's,
Okay, do they then have the opportunity to speak during public comment, or this would take care of all of that?
that's up to council.
Okay, so after they come up and give their testimony, we will hear from the other side, their attorneys. And
I will finish out my statements, and then you will hear from the
Okay,
other
all
side.
right.
Yes,
So
sir.
they'll be able to be cross-examined as well, is that fair?
Sure,
Okay, thank you very much.
thank you.
Thank you.
Could I give my hearing speaker's waiver form to?
No, you're part of the city's case.
Well, I don't think you'll need it now. How long do you need to speak? Or are you just going to let her, are you going to question her, or are you going to just have her speak? How much time do you wish?
6 minutes, please.
And how many do you have on the form here?
I have myself and then the other person.
Counsel,
She's part of the city.
okay, part of the city's case, then we'll just,
That can
Then
be
you
held
can-
for public comment if
Why-
needed later, if she's gonna speak now.
okay, then you want to just let her speak and then?
Yes,
Okay.
Yes.
That's the determination of council.
yes, you do.
If we need to.
Let's resolve this issue first.
Councilmember Clendenin.
If someone is part of the case, they're part of the case. There's no such thing as public comment at that point. That would be like having Susan come up for public comment. I mean, she's either part of the case or she's giving public comment. So I think we need to resolve that issue that, you know,
Yeah,
that,
she probably don't say everything.
right, exactly.
Yeah, exactly.
So, I mean, just so we know, we all have the same understanding that it's just the one bite of the
This is
apple.
sworn testimony.
Right, right.
Councilmember Carl.
But is each side governed by a certain total amount of time, so they can speak as long as they want? Is that what you're?
She said she only needs 6 minutes.
I'm just asking because we're trying to set the parameters so we understand.
I
Ms.
mean,
Johnson Velez.
this is part of,
There's no time frame.
I'm just asking in this
Correct.
format, is there?
correct, there's no,
Okay.
correct.
All right, go ahead, please say your name.
Good day. My name's Allison Roberts. I reside at 3926 Americana Drive, and I appreciate the opportunity to speak with you today. I'm going to try to use this. All right, perfect. So I appreciate very much the summary that was provided to you and agree with and have seen much of that. I would like to provide some additional context in terms of the timeline, the impact, and really how we got here. So exactly 3 months from the date of the property's purchase by M2, the above complaint was logged into Excella. The city issued a notice of violation related to zoning roughly 3 weeks later, which you can see with this first red arrow on 12/16/21. And the yellow dots that hopefully you can see, you can see on here, they represent concerts, ticketed concerts that are going on during this period. 3 days, thank you. 3 days after that notice of violation, another complaint was recorded in Excella because the concerts continued. And the system again worked as it should. Mr. Piper and council found themselves in a hearing in January. The entire sworn testimony is truly worth listening to, but given our time limitations, I'm going to just provide an excerpt of that. So Mr. Piper, as you see in Mr. Porter, I'm sorry, explained his client's confusion. He asked for leniency. He indicated a clear understanding going forward. And there is a whole segment of the discussion that's really dedicated to the topic and agreement around getting temporary special event permits going forward. So in January 2022, we're good. But in March 2022 is the kickoff to Waters' concert season again. And the understanding reached in January did not stop Water from going into full gear. After multiple complaints, that you can see here in March, or in April and in May, because you see again the concerts going on. Each dot is a ticketed concert. Then Water enters into and requests an FDN, which was then used to continue code violation hearings until after their concert season, which was over in September. So 2022 had 5 months of reported noncompliance. In 2023 spring break, then started up again, and everything starts again. And there are numerous delays with the FDN, and it's drug out the entire 2023 concert season. And the city did not enforce the zoning violations during this time. So we had another year. In 2024, start again. So this is now after the FDN, after we've been in front of you, after we've gotten the formal decision. In 2024, here we go again. Spring break starts, the entire cycle starts again. Again, numerous delays and associated tactics, and here we are again, 4 days after the end of their concert season. It's been 2 years since anything was done to provide relief, and even the $30,000 in fine on October 22nd had no effect. The behaviors continued unabated. Today we're talking about a suspension of liquor license or liquor sales. And please note that while I support this wholeheartedly, It only has meaning during their concert season. I looked up again today to get most relevant information. The Godfrey Hotel and Cabanas has a 2.1 stars rating on Yelp out of 5. According to reviews, it's known for being dirty, moldy, drug-infested, loud, and with alleged prostitution. And from my experience, the bar and restaurant are a ghost town unless the concert season is going on. So that's why timing is important here. Again, this isn't really hard to figure out. The rest of the world knows that these are concerts. Ticketmaster has DJs listed under the category of concerts. The same performers. And why does ignoring the law and process matter? So according to Waters' legal counsel on behalf of Mr. Piper, since Piper Productions has taken over, there's been increased professionalism, fewer complaints, and a safe environment. So this was in 2021, sworn testimony. So to verify this, let's just take a look or peek at some of the things that have happened since that statement in January 2021. I reviewed TPD's calls for service over 1 year, 2022, and a portion of 2023. And here's what I found. 159 reports of disturbance of music over that period of less than 2 years. 714 events over a period of less than 2 years, excluding bar checks and that kind of thing. The above analysis doesn't include other precious resources like fire and rescue and other City of Tampa officials' time. There have been multiple calls for rape, sexual battery, person in crisis, guns, battery on law enforcement officer, and a variety of other violent crimes. And I will also share with you that multiple people have told me that they feel threatened by Mr. Piper, and one witness backed out this morning because she's terrified. In 2014 and 2015, under similar circumstances involving Mr. Piper and different ownership, City Council set up multiple checkpoints on the calendar ahead of time to coincide with their concert season at this location. This allowed for immediate action, and it was only then that they came into compliance. I ask that the city agree on a suspension today and carefully consider timing of such and the addition of checkpoints. Doing so can restore the property rights and quality of life to surrounding property owners, and it could provide some solace to those whose lives have been placed in jeopardy or forever changed. Thank you.
Thank you very much. Who is the next speaker? Yes, ma'am, please say your name.
Hi, good afternoon, everyone. My name is Katie Heckert. I've lived in the Danish Shores Rocky Point area for over 10 years, and I'm here today because I'm concerned about the safety of our community. On a recent afternoon, I was out for a bicycle ride with my husband and our 2 children, aged 5 and 8, enjoying a beautiful ride on the Courtney Campbell Trail near the water. When we encountered a dangerous situation on the Courtney Campbell Trail at the intersection traffic light near 7700 Courtney Campbell Causeway, located in front of water. While we were waiting for the light to change so that we could cross the road at that intersection, a group of young women was attempting to cross the street departing water, along with a steady stream of other people departing water. And again, this is mid-afternoon. And the young women were so intoxicated that one of them fell down in the middle of the intersection and was so intoxicated she could not stand back up again. And additionally, her friends were so intoxicated that they had a very difficult time getting her back on her feet and out of the middle of the intersection. I was concerned that I was going to have to leave my children and the bicycles on the edge of the street to ensure that none of these young women were hit by a car. Fortunately, they were able to get it together and finish their way across the street. At the same time that was happening, in the stream of people departing water, the vast majority were visibly intoxicated and generally appeared to be walking to the nearby parking garage, presumably to drive home. Given the shocking level of intoxication of the crowd, my family and I did not feel safe. I was concerned about a car swerving off the road onto the sidewalk and hitting us on our bicycles, given the level of intoxication I was seeing. I didn't think it was an appropriate environment for my children, even though, again, this was only late afternoon. As a result, instead of continuing our ride, we made the safe decision and returned home. Since this experience, I've only been comfortable riding on that beautiful trail during the mornings. I haven't returned at all with my children. The incident has left me feeling very uneasy about that area and really worried about potential drunk drivers in the area at any time of day. So I'd ask that you please do whatever you can to address the public safety issues stemming from the establishment. And thank you so much for your time.
Thank you very much. Who's next? Come on up, sir. Hello, sir. Please state your name.
Yes. My name is Brian Roberts. I'm a resident at 3926 Americana Drive, which is approximately twice as far as the parking lot where the officer heard the noise. I'm going to go through this pretty quick. The owner of Water purchased this property 11 August 2021. Since then, I believe that there have been roughly 162 concerts in a little over 3 years. As mentioned earlier, the PD allows for 4 temporary special events, 2 weeks long maximum, and if they use both Saturday and Sunday for concerts, that would be 16 a year. On January 5th of 2022, the owners of the property said to the magistrate that they understood the PD required them to file a temporary special event permit to hold concerts. Since August 11th, I only found 2. You found 4. I found 1 for New Year's Eve on 2021 and New Year's Eve on 2023. If my counts are accurate, there are over 160 irreparable violations since this owner has taken possession of this property. I'm going to highlight the concerts here real quick, before and after Resolution 889. I sent this PDF to you guys. I don't know if you received it, but it has, you can look up the dates of all the concerts. These were all taken from the smugmug.com website where Piper Productions has their material. So this is going to be March 4th through March 26th of 2023, 7 concerts. April 2nd through April 30th, 2023, 9 concerts. May 6th through May 29th. 2023, 9 concerts. 6/3/2023 through 6/25/2023, 7 concerts. 7/1 through 7/29, 11 concerts. 8/5 through 9/4, 11 concerts. Resolution 23889 goes official on September 7th, 2023. 2 ticketed concerts. 9/16 and 9/17, 2023. Water 2024. March 23rd, 24th through April 21st, 9 ticketed concerts. April 27th through May 26th, 9 concerts. May 27th through 6/29, 9 concerts. That might be a duplicate sign, right? 6/30 through 7/28, 10 concerts. 8/3 through 9/7 of this year, 9 concerts. In closing, based on the analysis I've done, prior to the resolution in September 23, they were averaging around 2 concerts per weekend and more on holidays. After the resolution, they were averaging around 2 concerts per weekend and more on holidays. To me, it doesn't look like Resolution 889 had much of an impact on the land use by the current owner. Please help. Please take your time when applying whatever penalty you're going to apply. You've got till the end of March to figure out when you're going to do this. If you apply it between now and then, you're throwing an opportunity away. There's going to be no impact. The bar is completely dead right now. So please take your time, think through if there's something else that you can put in place between now and then that you can use to apply this. But there's obviously a real problem out there, and they obviously don't have much of a thought for what you guys say or what we're asking them to do either. This is gonna be 2025. Also think next year, they have the opportunity to do a land use change where they might ask for commercial intensive. If that gets stuck in the courts, we're gonna be this time year, next year, going, gee, they had another concert season. So please take all of that into consideration when you determine what you're gonna do and how you're gonna do it. Thank you.
Thank you very much. Who's next?
Mr. Chair, we have one more speaker for the city's case, and then one speaker who would like to speak during public comment.
Okay. Yes.
Hi. Thank you for the opportunity to speak with you today. My name is Renee Saltzman, and I reside at 3926 Versailles Drive in Dana Shores. Just to give you an idea of where I live, this will come up on the screen here.
Yes, we see it.
This is, of course, water. And I live all the way over here, and I can hear their music regularly. In fact, my husband and I spent over $10,000 on impact windows so that we can no longer hear water. We're getting ready to spend another $19,000 so that, we do not hear the loud bass in our house. But my main point is, I have a video to show you, and this video is just an excerpt. It's only 40 seconds long, if you will allow me to play it for you.
Go ahead.
It's been dated, which is also very helpful, 2024. And this is a good representation, not only how water kicked off the start of their 2024 season, it's also a representation of what has continued through their regular season, which apparently just wrapped up this last weekend. I don't believe that any reasonable person who's honest could argue that this is not a concert. We have some of the highest paying touring musicians in the entertainment industry with dancers, crowd interaction, instruments, etc. We also have tickets here for general admission associated with this period of time of 2024. And I will just very briefly show you the tickets and the time dates. We didn't want to print all of them out for you, but this is March 2023 of 24, and the dates continue to...
turn it over.
Oh, I'm so sorry. And the dates continue there. Put this down a little bit further. And I just have 3 sheets very quickly to show you.
You're going too fast.
Oh, I'm so sorry. I just don't want to take up too much of your time. And I can turn this all into you. I don't need any of this paperwork. We also have concerts that show VIP ticket options at nearly double the price of general admission tickets. And here you will see that the VIP ticket is $65. Oops, let me bring that down a little bit so you can see the price of that ticket is $65. And the promoter also provided table options, which is very similar to like sporting events, maybe hockey events, for the price of what the tickets are for. Here we are. Sorry that's not clearer, but anyway, I couldn't fit all of the pages for all of the options for the tables and the cabanas, but they range from $175 to $750 a table. And here's what I've come to the understanding through with these numbers of their ticket sales, cabana sales, table sales, alcohol sales. It would be very difficult, not if impossible, to incentivize compliance merely through fines, as we have continued to see with water. I think at this point, they probably just see it as the cost of doing business because they're making so much money. But it also shows water's blatant lack of respect for the city's law and ordinances. And I ask that you please impose the maximum suspension of water's alcoholic beverage sales. Thank you very much for your time.
Thank you very much. Ms. Johnson Velez, you said there's one person for public comment? Okay.
Thank you for that. Oh, may I add something also? There have been repeated times that I've had to call the police to talk about the noise in my home that we can hear in our home. And on one event, one of the officers came out, as they are always so helpful, and Mr. Piper showed up at my house. And I don't know if it was because he was standing out one of the officers that they hired, but it made me very uncomfortable that I'm calling to make a complaint, and this man shows up at my house. Also, one other time I went there and I just said, listen, obviously in the last 10 years, we haven't gotten very far with you. Just be a better neighbor and turn down the music. Just, calm it down, turn down your bass a little bit. And he kind of got in my face, all puffed up, and said, I have the right to be here and I'll play it as loud as I want. And I said, you have night shift workers, babies, people that live close by. I said, when I go over to my friend's house, her windows and doors are literally vibrating because your bass is so loud and the music is so loud. So I just wanted to end on that note. Thank you very much for your time.
Thank you very much.
Thank you.
Susan Johnson Velez, Legal Department again, Mr. Chair. Just a couple of housekeeping things. I do have the items that I put on the Elmo on behalf of the city that I would like to submit for the record, and I have Ms. Roberts' documents that she showed, as well as Mr. Roberts. So at the conclusion of my remarks, I will hand those to Mr. Shelby for the record. The city believes that we have established violations of Section 27318C1, subsection D, subsection L, and subsection N, based on the evidence and testimony that you've received at the hearing at this point. The city is asking for that City Council find a first violation. You'll recall that pursuant to this section, first violation carries a maximum penalty of a 30-day suspension, but then there are progressive penalties for subsequent second and third violations. So we're asking for a finding by City Council of the first violation, imposition of the maximum suspension period of 30 days at the conclusion of this hearing. And if that is council's pleasure, I can assist with those timeframes, because we would need dates and times for the suspension period. So that concludes the city's case. I believe Ms. Batzel is here on behalf of the property owner. And there is, again, one other resident who would like to speak during public comment.
Okay, so at this time, we'll have Ms. Batzel and then public comment.
That's correct.
All right, Ms.
Thank you, sir.
Batzel, come on up. Please state your name and you may begin.
Good morning. Elise Batzel, Stearns, Weaver, Miller for the record. Can I have the presentation, please? Before I get started, I did want to let you know that I'm not Jim Porter and we're not here representing Pied Piper. We're here representing the landowner, M2 Tampa LLC. With me is Nathan Logan, who is the general counsel of M2, who has flown down here from Chicago to be at this hearing. Before we start into the presentation, I also want to let you know that the owner is here to fully take responsibility and not to contest any evidence that has been presented into the record today. We also would like to be here on behalf of the owner to apologize to the city council, to apologize to staff who has spent endless hours on this matter, and to apologize to the community. And most importantly, want to inform you that as of this morning, the relationship and agreement between the owner and Pied Piper has been terminated. Those are very important facts that we want you to know before we start into any information today. What am I doing wrong with the clicker? Yeah, right here. Maybe I'm not, it doesn't seem to be working. That's okay, I've got a paper copy. Always good to have a paper copy just in case.
Yes.
Got it? Okay, that's okay, bear with me.
Oh, there it is.
Oh, here. There it is. It's working now.
Thank you. You know where the property is. I'm not going to repeat what Ms. Johnson-Velez has already indicated to you. Again, this is the outline of the AB permit. I did want to put on the record that obviously things are going to change out there. But I wanted this council to understand and know that if you look at the location of all of the areas where there are music venues and outdoor entertainment venues, I did want to let you know that there are a number of additional venues that are close to the neighbors and close to Dana Shores. So if there are noise violations in the future, we're going to provide you with a lot of information as to how we're going to protect. But we just wanted geographically for you to understand that M2's property is not the only property out there that does have entertainment and outdoor venues, outdoor entertainment. Ms. Johnson-Velez already went over the permit history. I want to talk a little bit about the timeline because from an ownership perspective, October 13th happened when you all had the formal determination. Eric Cotton determined that the issue of whether outdoor ticketed concerts included this DJ event. That was appealed to the special magistrate. The special magistrate came back to you with their recommendation, and you found your finding. In September 7th of 2023, Mr. Porter and Mike Piper filed a petition for writ of certiorari to quash the final order of Tampa City Council's decision, and I understand right now that that is sitting in limbo and that the judge has not issued an order to show cause. The reason I'm saying this is that from an ownership perspective, there have been no new noise violations or anything issued since that period of time in September of 2023. So when they got the notice of intent saying that there was an issue today about suspending their license, they were actually surprised. I will tell you that, and Nathan will tell you that ownership's been a little bit asleep at the switch, but that notice of intent definitely got their attention, and we're here today to turn things around and make that right. So the owner is committing to several things. One, we are going to resolve any kind of code enforcement liens that are on the property at this time. We just got involved. We've determined that there are some outstanding fines. Those will be paid as soon as possible, but definitely within 30 days. We just need to know what those payoff amounts are from the city. We're going to resolve any outstanding permitting issues. We've recently discovered through our due diligence that there is a stage out there that is unpermitted. We've confirmed we will be taking that stage down. We'll probably have to get a demo permit from the city to do that. So I don't have a timing on here. We'll work as quickly as possible, but it will require the city to actually, I believe, issue a demo permit. We'll work with Eric and Building Permit in Camaria to make sure that that happens. And finally, we would like to establish an owner point-to-point for the city to call if there are any issues or something doesn't go exactly as planned. Does so that there is no more miscommunication. We do have a request in light of that information. We would request a 15-day suspension. This is an operating hotel. There is a restaurant inside. There are indoor events and events that don't involve Pied Piper Entertainment happening at the hotel. And so we would request a 15-day suspension to the outdoors only. Obviously, the noise issues relate to outdoor and how that's carried over water. But we would appreciate it if you would, allow alcohol to be served in the restaurant inside. We can regulate that through signage, just like you do anywhere where the limits of alcoholic beverage, there's signage to say you cannot carry alcohol beyond that point. We respectfully would request your consideration of all these facts that we've presented to you today. Again, we're not contesting the information or the notice of intent. We're available for questions.
All right, any questions? Councilmember Hurtak?
Yes, so you talked about the fact that you're the owner of the building and the property, terminated the contract
The
with...
agreement, it was not an official written contract. It was an arrangement and agreement with Pied Piper, but yes.
So there's no written, there's nothing written that says this has stopped.
No, but Nathan Logan, who's the general counsel, can confirm that on the record for you. He delivered that news to Mr. Piper this morning. We'd be happy to provide testimony to you on the record.
I would like to hear testimony on the record, and then I would probably also like to have something written. I think that would...
Since there's no written agreement, we can put a letter to him and submit it to the city within 30 days. But it would be saying that the arrangement, it is not a written arrangement. It's been something that's been going on since many years before our client owned the property. So there's nothing technically to terminate other than the verbal arrangement that has been happening. But I'm gonna have Nathan testify on the record, and we'll be happy to write a letter to Mr. Piper outlining this and copy City Council.
Okay.
Nathan, do you want to provide that testimony, please? Just your name and address for the record.
All right, my name is Nathan Logan. I live in Glenview, Illinois, 1515 Long Valley Road. Actually, I spoke to Mike Piper last night and delivered the message that we were not going to be holding any more events at Water. He would not be involved going forward. As she said, we'll write a letter to that effect. Hearing the testimony today has been a little bit moving. We understand the situation a lot better than we had prior, so that's the plan.
Thank you.
Councilmember Moran and Councilmember Henderson.
Let me see if I heard right, because everybody's speaking in a very low voice, and I don't hear very well. I don't comb my hair very well either. But are we saying that you had a business arrangement with someone, or someone with you, or someone with somebody else? There was never nothing written?
That's our understanding. We bought the property. These things were already going on. We have, we manage a lot of hotels around the country.
And again, I'm not a lawyer or anything like that. I don't want to be one, but
No, you
the
don't, sir.
liability would be an enormous responsibility to the owner, not the vendor.
We're
The owner's
seeing
the
that
one
here,
that
I
let the
believe,
vendor
yes.
in. I'm a criminologist, I'm not a lawyer. Thank you.
Anybody else? Councilmember Henderson?
Yes, thank you, Chair. Your company came from out of town today to be represented at this hearing, correct? Did you all know about these problems in the past? How long have you known?
I don't have a timeline in my mind, but I know we've, like I said, we have been relying on our local people, including the promoter that had been running shows at this club since before we bought it. He had what we determined to be competent counsel, Mr. Porter, representing him, and he was telling us, yes, we've got this violation and that violation, but we have this defense and that defense, and we were kind of letting him handle it because it seemed like he was handling it. But as Elise pointed out, like this proceeding today got our attention, and so now I'm here, and I am sorry for not being here earlier.
Okay, that just seems so loose to me for from a business perspective, especially in regards to the attorney asking for such a lenient, fine. I'm just trying to relate it to the length of time that the testimony has been presented from the residents of the nearby facility, and it's just been going on for a very long time, so I'm just trying to understand why you even had to come today if you don't know anything.
Not really sure how to respond to this.
Yeah, why are you, what do you know? How about that? That might be an easier question. What do you know?
Well, now I realize that the promoter that we had been relying on for information about the relationship with the city was giving us a partial view of what was happening and the legal position and the issues involved.
I can supplement that too.
I don't want to supplement from the lawyer. I want to hear from him.
So I'm sorry, what was the question? Why now? Well, obviously a hotel without a liquor license is at a business disadvantage. So we would like to retain our liquor license, and I understand that things keep going the direction they're going, we're not going to be able to do that.
Do you think that there should be some level of punishment, or can I ask that a question as, do you think it should only be 15 days? I can't ask that question.
Well,
It's not it's just a matter of,
my suggestion,
you know what, how about
it's
this?
a good
Let's just-
rhetorical question.
It is a rhetorical question, but there's a lot of evidence. You know what? I obviously am not skilled at these hearings. I have an opinion.
They don't happen often. So
We've been down this road before, and so I just will, wait to the end. I don't have any more questions for you, but thank you for your time, sir.
Sorry,
This
point
will
of
be-
order, with respect to the last question, we do have additional testimony to provide to the record, just for the record.
But I don't have any questions, that's all I'm saying.
But at this point in time, counsel, it would be appropriate to have your questions asked and answered, and then we'll get to the other points down the road, Councilwoman.
Yeah, that's true too. That was not the time for me to pontificate.
So,
It's okay.
just for additional clarification, again, Elise Batzel for the record, we were retained about 3.5 weeks ago. We had years worth of research to do to understand what had happened and when. We did a public records request, and it was so vast that the city had trouble providing us with all of the documents. We still don't have everything, but Susan Johnson-Velez was very helpful in getting us some critical information for this hearing. So when we say that we are trying to address it, there is a lot of history and a lot of information that we had to get caught up on in a very short period of time to understand the history of the violations, what was happening at the property. And so when Mr. Logan says that, he's here today because we've been piecing this information together over the last 3.5 weeks, and he thought it was important enough to come here and talk to you and be here in person. So I do think that's important for the
Okay,
record. And we still don't have all the information from the public records request, but we did the best we could today, and we got enough information to know that we're coming before you saying that we are not contesting that information. We are accepting responsibility. And so part of that, request for leniency is we understand it is our responsibility. But again, I do think that the owner was led a little astray with respect to how everything transpired and maybe got partial information. Thank you.
Councilmember Carlson, Miranda, Pondeno.
Ms. Batzel, and understanding everything you just said about trying to get into this. Two questions, I'll put them both out at the same time. One is, I remember the case from last year, and I don't remember all the details of it, but I remember it in general. But I wonder how, especially since the promoter did not have a written contract, I wonder how they had standing and why the ownership didn't come then and intervene at that time. And then number two, part of that case, which you talked about a little while ago, is that there would, or Ms. Johnson-Velez talked about, is that this has been a concert venue for a long time, and there's an agreement that allows certain special events per year. And so I wonder what the future is of this. Is it that does the new owner think that, look at this as a hotel and resort and does not plan to have these big special events? Or is it that, that they want to have the special events but stick within the guidelines that were set up several years ago?
So let me go to the first question first, and then we'll answer the second question. The first question was, why did the owner not intervene? My understanding, and again, in the last 3 weeks, I've watched the hearings, I read the pleadings. I don't know that a judge would say that Piper has standing. That's probably would have been contested if the city ended up going through the litigation and a judge had issued an order to show cause. So that's a very good and valid point. When I listened to the testimony of Mr. Porter at that hearing, again, I was not there, but I did go back and listen to the video. I believe that the issue that he had appealed was the issue of the special magistrate going beyond the scope of what the formal determination question was. And I reviewed it and I felt like that was accurate and valid and therefore was a grounds for appeal, probably a grounds for M2, but so it wasn't related to the underlying events, it was related to the scope of the authority and that, anyway, I hope that answered your first question.
No, but so the second question is more about, you know, as you know, land use or land entitlements go with the owners, and even if this owner decides they just want it to be a quiet resort with the people hang out, that entitlement still exists on that outside area. So what's your plans regarding that?
Well, I think what the owner is saying, and what we've discussed, is that Susan Johnson Velez set forth what was in the conditions of that non-substantial change, right? And there are a number of specific conditions about if you're gonna have a special event, you have to do A, B, C, D, and E. The idea is if they wanna have something at New Year's Eve, like all of the other restaurants around there, they will comply to the letter of everything that was put in that approval that the board or the city council before you approved. I mean, that is the idea. Not to have not to have someone come in and replace Pied Piper, if that's the concern. But to have, if there are special events, to, you know, comply with the law and comply with the requirements of the zoning.
Thank you for saying all that. Since the owner's rep is here, could he just say yes, that he agrees with that if he does?
Yes, I agree with that. Our intention is to comply with all of the requirements.
Councilmember Moran.
I just say, you have a fine attorney, she's been here many times, many years, and I never found her to be in any way disrespectful to your client or the city. However, there's a, even when one buys any type of a building, including a house, it's checked all the way around. When you pay an attorney, they do a due diligence, they hire someone, they check all the records in the courthouse, make sure there's nothing posted, nothing against the house. In this case, you bought a very expensive piece of property. And my problem with myself is somebody's got to be responsible for what happened there, whether it's the buyer, you're the one that bought it, and you didn't do your due diligence at that time, I guess, or if you did, you hired an attorney that maybe you could go back and ask for your money back. Because I'm serious. I'm not trying to in any way blindfold you or lead you down another primrose lane. There has to be somebody responsible at this hearing where it's either guilty or not guilty because of the action that were taken. Because if not, this case could be duplicated 100 times in this city and we're still back at status quo. We haven't done anything. So I'm not here to hang you by means anyway, but you have to be responsible for what you did or did not do.
Councilmember Condon.
I was on the minority side of the decision when one of the violations came up about what the definition of concert was, and you know, with special events. And I still think the city we need to be more clear or clarify those definitions, so that it's explicitly understood from all parties that are doing business with the city of Tampa what that means. Because I'm still, again, I go to Webster and I see something different than the majority on the council saw. But I think that we need to clean that up. That being said, I appreciate the fact that, but it's clearly it's true that this particular establishment has created more than its share of nuisance in the neighborhood. Not this, and actually now that you've clarified it, it's not the establishment. It was somebody who was allowed to use your property for these events that has created that nuisance in the neighborhood. And now that entity is no longer going to be permitted to use your establishment for that, so that it almost makes this issue moot. I'm really curious about what happened in all these violations because I see in them that M2 is named in them, but I don't remember M2 being represented here. I thought it was just Piper that was represented here during those violations. Is that, I don't know, is it appropriate to ask? Is it appropriate at this time to ask our legal what that was?
I can speak on behalf of M2.
Okay.
This is the first time M2's had legal counsel represent them at these hearings.
Okay, and that's interesting. Yeah, it's interesting. Again, I think we have some cleanup to do on the city side. I think the neighbors are within their right to feel like that the sanctity of their homes have been violated by some of the events that have happened here, but I think we can do better on the city side. But again, with what the ownership has said, I think it's a reasonable resolution to this. Well, my question was the beginning. Yeah, well, you're right. We're not, thank you for the clarification. You're right. You're correct. I'm pontificating when I said we shouldn't be.
We're the neophytes.
There you go. But thank you. Unless Susan, did you have something to add to that?
Susan Johnson, Velez Legal Department. So I was just able to confirm. So the prior case, if you will, that was before City Council was a review of a formal decision by the zoning administrator. And in that case, Michael Piper or Piper Productions was an authorized agent who was authorized by the owner, M2 Tampa LLC, to seek that formal decision. So it's a case where the promoter, Mr. Piper, was authorized by the owner to seek certain approvals or things from the city.
Okay, thank you.
Thank you very much. Ms. Johnson-Velez, well, does that complete your testimony?
Yes, sir, we're finished, just available for questions.
Thank you very much.
Thank you.
Ms. Johnson-Velez, where do we take it from here? All right, is there anybody here that would like to speak for public comment? You would have 3 minutes. I know we've had quite a few speakers, witnesses. Come on up, you'll have 3 minutes. This is general public comment. Please state your name.
My name is Sandrine Gaz. Before my time begins, though, I think I have a sheet for an extra 3 minutes. What do I do with that?
Those are on there. Just one, that would be an extra minute. Yes, that's the fine print. Sorry about that. Ann Tate, are you present? Where's Ann Tate? Thank you. That's one additional minute for a total of 4.
Tell me when to start.
Yes,
When the
ma'am.
green
Go.
light goes on.
Okay,
Please state your name and you'll begin. The green light will come on.
thank you. My name is Sandrine Gaz, and I live and have lived about a half a mile from WTR for over 5 years. I want to start by addressing what's been said. First, I want to say thank you to you and thank you.
No,
Sorry.
you have to face
I want to
up.
say thank you to the people who just spoke for changes that are promised. But I want to tell you that while those changes that I'm very much looking forward to are welcome, the people who have been harmed for quite some time. You heard testimony today, and it was not refuted, that somebody showed up to an owner, had somebody come to their house, not the police, but Mr. Piper. How intimidating is that? Who wants somebody to come to their house like that? I understand that they're taking responsibility now, but that doesn't change what happened in the past. I am not excited about the fact that they're only asking for 30 days. A 30-day suspension, in my view, for all of the things that have happened is not enough. So the idea of going down to 15 is even worse. And again, I want to reiterate what's been said. That 30-day period needs to run from like March 15th to April 15th to have any real consequences. So while I'm excited about the changes that are coming, the harm has been done, right? There are consequences to being an absentee owner. And one of the consequences is you are responsible for what happens there. So wonderful that we're making changes going forward for the establishment, but there have to be consequences. And that's the consequences of being an absentee owner. Thank you for giving me the opportunity to speak. And I come before you, I've already said this, to urge you to take meaningful action for all that has happened. First, I want to emphasize that what's happening there is no occasional small nuisance. Rather, when these events occur, they have significant negative impact on me, my neighbors, and because of the fact that they drain the resources that all Tampa residents depend on, I would argue that they have an impact on everyone who's in Tampa Bay. It's not just noise. You heard, and it was accepted as true, that there are people that are crossing roads in very dangerous circumstances. Their business model depended on loud music, a huge crowd, a ton of alcohol, and basically violating the laws of Tampa Bay in order to be successful. The City of Tampa requires businesses to obtain special events permits for a reason: to ensure that events are conducted safely, responsibly, and in compliance with city regulation. Public safety matters. I don't have to tell you that. This is why you all are here, because you care about the citizens of Tampa, and they should be having to go through permits. Unfortunately, they've delayed things. Like I said, it is great that they're changing, but that's not enough for the harm that's been caused to the people who live nearby and what we've had to go through to get to this point. I think it's very, very notable and telling that now we have the owner who's here, who's saying, we will stop. I've fired Piper. We don't actually have a contract that I can show you. That's very notable. They're about to face large sanctions, a real penalty for the first time in years. People have fought for this for years. It has cost the city thousands of dollars in people coming here, right? And I have been at hearings where your residents are hoping for your dollars, our dollars, for public city dollars to be spent on community centers and roads and all of these wonderful things. Those are the conversations we should be having, what to do with our public resources. Public resources were never meant to have one person profit from them, and that's what happened. They have profited from abusing the laws. There need to be real consequences, and those real consequences has to be a 30-day suspension, what they're asking for, starting March 15th and April 15th, 2024.
Thank you very much.
Thank you.
Next speaker, please. Do you have a speaker waiver form as well?
I do not.
No? Please state your name, sir. You have 3 minutes.
Yes, good afternoon, Chairman Maniscalco, council members. I'm Giovanni Geritano. I'm an attorney at Bradley, and I represent Mr. Piper, who owns and operates Piper Productions, which you've heard about today. There's been a lot said today and suggests that this property is being operated without regard for this city's ordinances. And a lot of that blame is being placed on my client. And frankly, I think that's unfair. So I want to take a few moments to clarify some of the testimony that you've heard today. My client has spent a lot of time, energy, and frankly, money to work with the city to address some of their concerns and the neighbors' concerns. And I've been part of those discussions, so I can attest to that personally. And unfortunately, this property has a long history that predates my client's involvement with the property. And I mention that only because the issues that arose prior to my client's involvement really provide a lot of color and context for some of the frustrations that you're hearing from the residents today. And I hope you take that into consideration when you're making your determination today. You've heard that there are two primary issues before you today for the AB suspension hearing. There's a failure to obtain special event permits, and then there's a singular noise citation. So I'd like to start with the special event permit issue. My client has always believed he's been operating under the conditions of the PD, and that's consistent with the testimony you've heard today. Granted, there is a dispute between my client and the city of what the PD allows, but that is pending in litigation. It's an issue pending on appeal. So honestly, it begs the question whether the special event permit issue should even be a part of council's determination today, given that a court of law may determine that his position is actually the correct position, and may very well mean that there were no violations at all. As for the noise issue, my client has been working with the present owners for roughly 3 years, and there's been a singular noise citation issued, a singular noise citation. You've heard testimony that there's been many complaints, but only a singular noise citation. That happened over a year ago, and since that time, my client has taken steps to mitigate those issues. He's hired AV consultants, rearranged speakers, put limitations on what could occur at the property. Tellingly, there have been no other noise citations issued since then, absolutely none. So again, this is not someone who's just thumbing their nose at the law. He took this matter seriously, put into action mitigation efforts, which seemingly have worked, given that. Thank you.
Thank you very much. You have 30 more seconds if you need to.
Sorry. Thought that was my time to go off, which seemingly have worked. So I ask that you take that all into consideration. There has been some comments about my client personally. Frankly, they're disappointing to hear. I think his efforts to try to address the city's concerns may have been taken out of context and misconstrued by some of the residents here, but he has a genuine desire to address the neighbors' concerns and has offered his personal contact information to folks who have expressed concerns so they could come to him before
Thank you
any
very
formal
much, sir.
complaint.
Yes, Mr. Shelby?
If you have any questions of this, gentleman.
Because it's public comment. Yeah, but we don't comment.
Comments over.
Oh, then you could call it up? Okay, thank you.
Yes, ma'am, please. Next speaker.
Good afternoon, Stephanie Pointer. I had no intention, but then I was having deja vu. I'm like, man, we've seen this crap before. And then I'm like, wait a minute. Okay, so questions to ponder. If this was a house down the street from you and this was an Airbnb, would you shut it down? You betcha. If you could, you would. Who in the world operates without contracts in 2024? That is the craziest thing I've ever heard. I love me some Miss Batzel, so I believe that she's telling you guys 100% accurate information, but I just find that very, very difficult to understand and comprehend. And people who do business without contracts, well, you do the math. But I find it hard to believe that we had special event licenses and then we didn't have them and then we did have them. And you know what? Every time that they got a special event license, that tells you that they knew the rules and then they went and did it again without a special event license, which means that they don't give a crap about the rules. So that's where the problem comes in. But any landlord on the face of the earth should have a better idea of what's going on at their property. And last time I saw it, when we send out neighborhood notices here in the city of Tampa, we don't send it to the tenants. Guess who we send it to? The owners. I'm glad they're here today, and I hope they fix the problem. But please keep what these neighbors are saying in mind, because they deserve to have peace.
Anybody else for public comment? Councilmember Clendenin, I saw your microphone.
Yes, for our attorneys. So there was comment that, and I believe this was in testimony, that there is a case pending litigation and outcome about whether or not these events are considered special events. Is that true?
Yes, so let me back up a little bit. The last time this property was before council was on, to consider the recommendation of a hearing officer. So I'm going to back up one more step. So in response to the code enforcement case and the findings that the property owner had failed to obtain the required temporary special event permits, Mr. Piper's attorney had said that his client always believed that he was operating pursuant to the zoning approvals. So Mr. Piper, or on behalf of, or with the authorization of M2 Tampa, LLC, sought a formal decision from the zoning administrator specifically to ask, am I in compliance with my zoning conditions? Mr. Cotton issued a decision letter that stated you're not in compliance with your zoning conditions because you're supposed to go get a temporary special event permit and you're limited to 4 times a year, et cetera, all the things that were listed in the conditions. So Mr. Piper sought review of that pursuant to the city code. Those reviews go to a hearing officer. The hearing officer determined and recommended that city council uphold the zoning administrator's determination that in fact Mr. Piper was not operating in compliance with the zoning conditions. And city council did in fact uphold that decision. Now, there is a case pending for almost a year now in Hillsborough County Circuit Court where Mr. Piper is challenging city council's decision, but no one has overturned that decision. City council's decision stands as made almost a year ago, that in fact the property is not being operated in compliance with the zoning conditions or the substantial change conditions, and unless and until that decision is overturned by a court, that decision stands.
So in your legal opinion, if this council made a decision based on that pending decision, and or council was overturned in that pending decision.
None of these things are.
And none of this is related to that?
None of
So
this is
your case is not dependent upon the special events or anything has to do with that, okay?
Well, if you get the answer to that question on the record, please.
So the city's case is not dependent upon anything that is pending litigation?
No, it is not.
Okay, okay, good, okay, that's good. And there was also a statement that there's only been one noise complaint found?
There's only been one conviction of a violation of chapter 14 of the city code, which is your noise ordinance. I showed you the documentation. There was a citation that was issued in April of last year, and the case went to trial, and there has been a conviction or a finding of guilt.
So can you refresh my memory what basis you're asking for 30-day suspension on?
On the...
I know, but I mean the specific incidences that led you to those. I understand from the code, but what specific incidences are you asking to follow into that code?
Under...
One noise complaint.
Well, the code lists a violation of chapter 14, the noise ordinance, which we have shown that there has been. We have shown failure to comply with zoning conditions or conditions that were placed by city council or the city for any approvals. So that relates to the rezoning approval and the substantial change approval, and specifically the failure to comply with the requirement to get a temporary special event permit.
Isn't that what's pending though?
No, that is not what's pending.
You may want to have testimony from Mr. Cotton as to exactly what the issue was, just so it's clear for the record.
Yeah, because
that
that's
it's
what I
not-
thought was pending.
Well, and the basis is that there are three code enforcement cases, three code enforcement orders where there's been a specific finding by the code enforcement special magistrate that there's been a violation of section 27-282.16 for the failure to obtain a temporary special event permit. They were ordered to cease holding special events unless they went and got a special event permit. They were told you're limited to 4 per year, and those orders were not contested. Those orders are final. They were not appealed. And so we have 3 separate code enforcement orders that form the basis of that violation, failure to comply with conditions of approval.
So,
And then-
Marty asked about for Eric Cotton to come up and, so to clarify exactly.
The
Okay, go ahead,
formal
I'm sorry.
decision is not the basis for the notice of intent to suspend. It's the 3 code enforcement cases, the 3, and I
But aren't
showed
the
you all
code
of the.
enforcement, aren't the code enforcement cases, aren't the code enforcement cases about whether they needed a special event permit or not?
No, the code enforcement cases were about whether they had a special event permit, whether they conducted a special event without a permit. And those cases they were found in violation for that by the code enforcement special master back in 2022.
Oh my gosh, I feel like I'm like missing something here, because what I'm, okay, I'll let my time go for right now and revisit maybe.
The formal decision was irrelevant to those code enforcement cases. That was not the subject of it. It was alleged violations that the code enforcement special master said, yes, there is a finding. I find that they are in violation. I find that they have violated 27-282.16. I'm imposing a $1,500 fine for the first case. They're a repeat violator because they have now conducted another special event without getting the required permit. So I find that they're a repeat violator, and I'm imposing a $15,000 fine for the second case. And then the third case, same thing. Didn't get a temporary special event permit, which you're required to do under your conditions of approval of your zoning. And so I'm fining you third violation and another $15,000 fine. Excuse me, those are the 3 cases that form the basis under the heading of failure to comply with conditions of approval. So you have the noise ordinance, you have failure to comply with, as evidenced by the orders of the code enforcement special magistrate, and then you have all of the testimony that you've heard from neighboring residents about the negative secondary impacts to surrounding properties.
So, with this, let's say this pending litigation. If this pending litigation overturned the decision, those cases you just referred to, would they be overturning those decisions as well?
No, not the code enforcement special magistrates. No, those are final, those were not appealed. Those are final and not appealable.
Okay, thank you.
Thank you very much. Carlson, Henderson, Hurtak.
Three quick questions. Back to the comment about one violation a year ago. Do you track or do you have a record of were there other complaints since that point a year ago, and how many were there? Or any other data on that?
I believe Ms. Roberts testified to that, if you would like for her to come forward. And those citations are issued by Tampa Police Department, so I don't know if you would like to
No,
ask.
but does staff have that? I just,
My suggestion is if there's somebody who's able to testify to it.
but those are members of the public, not
They
staff.
are.
No, but they were part of the city's case.
If I can, counsel, let me just be able to resolve
Okay,
this issue.
let me ask my next question then while you
Okay,
guys
then I
figure
need
that
to-
out.
Mr. Chairman.
Because and the next one gets, I want you to answer this, please. You got up a few minutes ago and said that in the case a year ago that this promotion company was an official agent of M2 or whoever the owner was. Can you say, when you say they were an agent, does that mean there's a written document that's signed by
Yes.
M2 that says they are an agent? Okay, I just want to
There is.
clarify that.
Yes, there is. I'm happy to submit it in
Okay,
the
so
record.
it wasn't a verbal thing, there is a
No,
written
we would-
document?
No, we would have to, the city requires if someone other than the property owner is seeking an approval, for example, in a rezoning or an alcoholic beverage permit,
Okay.
if it's not the owner.
Yeah, I just wanted to make sure that it was a
We do have a
official
written
formal,
document.
because they
Yes.
talked about not having a contract, and I just want to make sure there was a contract there, or a document there. And then the M2's representative has recommended that any penalty be impacted only on the outdoor area, not on the indoor area. Is that allowable?
I mean, I have spoken to staff about that.
Is it allowable
and
under
Mr. Cotton-
the law?
Well, I think it's not feasible, it's problematic in the sense that this alcoholic beverage permit, if you will, wet zoning, applies to the entirety of the property. And so from an enforcement standpoint, it would be difficult to cordon off, what area are we talking about? Does somebody have to go out and stake it out? Typically, and I believe Mr. Cotton can confirm this, when we have done these in the past, there's never been a suspension of a portion of.
It looks like Ms. Batzel wants, can I ask her for an answer on the same question, please? Just,
Then I'd like to speak to it as well.
okay.
Mr. Shelby.
Could,
But you could- well,
maybe you can comment on what both of them say, and let Ms. Batzel speak.
Okay, well, but you're arguing on a point, but then again, I just want to bring to council's attention, and Ms. Batzel can contradict me if she likes, and perhaps she has some case law about this, but I look, council, as you should look to what the code says, and the code says specifically two things. Is there a violation? And if there is, there are specific penalties. It says nothing about, and you heard testimony, uncontroverted, that the wet zoning applies to the entire parcel. I think for council to impose a penalty that is outside of what the code says would be ultra vires, and you'd be acting outside of your purview as to what the penalty or remedy would be. That's my opinion, council.
Thank you. Could I just get Ms. Batzel's response?
Yeah, I disagree with that. The code says a maximum of 30 days, and you sometimes issue 15 days. I mean, this council has the authority to issue what they see fit within the confines of the code.
Do you know any case law or something you could cite that? Okay.
No, but for example, you do wet zonings, and there are requirements on the wet zoning that say indoor, outdoor. You're worried about where is that? Well, it's indoor or outdoor. I think it's very clear what indoor is compared to outdoor. Ms. Johnson-Velez and I discussed this before, and just because staff's never done this before doesn't mean that it's not possible to do. There are many wet zoning areas that you can clearly demark what an indoor versus an outdoor area is.
Yes, Ms. Johnson-Velez.
Thank you, Mr. Chair. Susan Johnson, Velez Legal Department. I think the distinguishing factor in this case is this is a 50-year-old wet zoning. Back then, the city approved them for the entire parcel. And so I appreciate what Ms. Batzel is saying, but we actually approve alcoholic beverage permits differently in this day and age. We actually have a site plan. We have a legal description so that you have a specific legal description for an indoor area or an outdoor area such that it can be easily identified. But in this case, it would be very difficult, I think, and I think Mr. Cotton can speak to that just from the staff perspective in terms of trying to enforce that, if there is a suspension imposed, to try to figure out which areas and cordoning off, and I think it would be difficult from a enforcement standpoint. I'll have Mr. Cotton maybe come up and.
If I can, counsel,
Yes, sir.
this I'd like to have bifurcated. And with an alcoholic suspension hearing, it's really a two-stage process. Before you get to the penalty phase, my suggestion is, and you can take as much testimony as you want, there has to be a finding of whether there is or there is not a violation. If there is no violation, then this is all not necessary to discuss. What you need to have fine if you want to discuss that, and if you want to close when your time comes to close the public hearing, is I will ask you to make a finding as to whether or not there is a violation before you get into the discussion of whether and what, and the code specifically states, which I suspect will be discussed, exactly the specifics in the code as to how you weigh in determining whether to suspend or revoke an approval to sell alcoholic beverages. City council shall consider, and that would be discussed after such a finding. I want to clear up one other thing for the record, and this is very important. This is not general public comment. This is an evidentiary hearing of this board with witnesses that are before you. Council may be confusing this with the rule that says council members should refrain from engaging a speaker in dialogue during general public comment. This is not general public comment. What you have before you are people who are offering you testimony. If there is anything within a testimony, and not to this hearing, it's to any evidentiary hearing that you have. If there is something that you need to know in order for you to make a decision, and somebody who's testified to having that knowledge, you can ask a question to elicit that information so that could be placed into the record as competent substantial evidence upon which you can base your decision. So you don't have to listen to everybody because somebody could be offering some comment you'd want to ask a question. There's nothing to keep somebody from walking out the door. The time to ask the question is after they testify.
Thank you.
Councilmember Henderson, then Hurtak.
Thank you so much for that, because that's what we should have done the last time, is make a decision first. I want to ask, if that is the case, I would like to ask the guy who got up and spoke on behalf of the violator of all the parties, that guy?
Mr. Piper?
Piper, yes.
Okay, Mr. Gentile.
Yes, sir. I have a question for you. Are you, yes?
I'm just asking if you could just state his name again for the record so it's clear.
Yes.
Thank you.
Please state your name, sir, again.
Yes, Giovanni Geritana, the Bradley Law Firm.
Are you aware of that the relationship with your client has been severed with M2?
We were informed this morning that they intended to they are severing the relationship.
Okay. Are you aware that your company has been in violation of all of the infractions for a long period of time? And did they do anything to try to circumvent that?
My client 100% did try to make efforts to be in compliance.
They stopped having concerts where they was charging people, having events. They applied for some.
Yeah, so I'm happy to provide you some additional context about the various events that were testified to.
Not the various events, but event number 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Those events. Was your client aware of all those events?
He was aware. The first violation that you were provided as a basis for this AB suspension hearing, between that time and the hearing on the other two, he filed the formal decision notice. So the formal decision request. So the first violation in 2021 was had. Mr. Piper then decided to file the formal decision letter. And a week after the decision was made, there was a hearing on the other two that are forming the basis of this hearing. To provide you some context of his understanding that he was in compliance with the law. That those second and third violations, those findings happened after he submitted the formal decision letter.
Would you consider anything after number 4 a violation?
No, ma'am, I would not.
Oh, wow, okay,
Because
okay.
this is a contested legal dispute that is presently on appeal.
Understood. What is, since your organization did not have a formal contract with M2, what was the relationship? What was the agreement?
My understanding was
They could have concerts?
I don't have the details of the formal arrangement between the two parties. I haven't seen a written agreement, so I can't testify to
Okay,
that.
so what are you here to do today, then? If you don't know that, what are you here to do? What is your end goal?
I'm sorry? I'm sorry, can you
What
repeat
is
the
your
question?
end goal if you're not aware of, what your client is, purpose of being in a relationship with the M2 and utilizing their facilities? I'm just trying to understand.
Sure, I'm happy to address that. After we were informed this morning that they were severing the relationship with my client.
What relationship specifically?
For my client to coordinate DJs and provide music through DJs at the hotel property. That was the arrangement. Those are the only
Beyond number 4?
Yes, beyond number 4, because what's contested before court is whether or not having a DJ is a ticketed outdoor concert. That is what is on appeal. Whether having a DJ play music is a ticketed outdoor concert, and so whether there is a prohibition for them to allow that on a weekly basis. The special event permits that you heard that were pulled, those were pulled on days that you would expect to have large crowds, New Year's Eve, for instance. And so it wasn't because they knew of the law and didn't want to comply. They anticipated on those weekends having large crowds, and they wanted to be in compliance, so they submitted a request for those special event permits for those particular dates.
Okay, thank you, sir. Appreciate it.
Councilmember Hurtak.
I have some questions. I have a quick question for Ms. Batzel.
Thank you.
How can we guarantee that DJs won't continue at this property?
Well, I think that under the special temporary event and the parameters that are already in their zoning, DJs could, on a very limited basis, continue.
And what would those limited basis be?
I can read them back into the record. It's all the parameters that Susan Johnson Velez
Okay,
read into the record.
so you're
related
saying
to
the
zoning.
site plan parameters?
The site plan parameters, and to the extent that a temporary special event permit is required under the code, we would have to get a temporary special event permit under the code.
Okay, thank you. I have some questions for Ms. Johnson Velez. Who paid the $31,500 in fines?
No one has paid those yet.
Okay. Are property owners notified when the individual, the person leasing or using or representing, so say I owned a property and there's a restaurant there. If they get a noise complaint or any other type of violation, would I get a notification as the owner of the property?
So for the code enforcement violations, the owner of the property is the one who has provided notice.
So then M2 has gotten every single, what about the noise? So there have been 264 some odd noise complaints. They have received every single one of those?
Well, I don't know what the response was to those noise complaints, because again, those are phoned into Tampa Police Department. So I do know of the one, and it just shows the address on the citation. There's a name on the citation. I'm not sure who that person is, except to assume that they were on site. And whatever the defenses they may have provided at the county court hearing were not successful in avoiding a conviction or a finding of guilt for the noise violation.
Okay, and then I have one more question for you. How can we guarantee, the city, that the DJs won't continue?
I don't know how you can, I don't know how you could guarantee that.
Thank you. And then I have a question for the woman who spoke first in the green shirt. I'm so sorry I don't have your name.
Yes, ma'am, it's Allison Roberts for the record.
Thank you, I appreciate that. You had that, a slide that showed how many different complaints were brought in? Oh, I'm sorry, I didn't realize that had already been given.
That's okay.
I think it's those. Yeah, it's that one. And Annie, if you wouldn't mind just putting that slide back on the Elmo for us, I just want to be able to clarify and then ask. Not that particular one. There's another one you had of all. Well, you can leave that one there, but the one that had all the numbers of the complaints that had been called in. I think. Oh yeah. Hold on, just a second. It likes to restart itself every now and again.
Okay.
It's tired. Yes, there you go. Thank you so much. So I have a question for Mr. Cotton about this particular slide. So when these are called in, what is the difference? Because there was a call for noise. Ooh, where were the noise complaints? So disturbance music, 159. So when those are called in, what is the difference between a noise complaint and then what was finished at the magistrate, which was the noise, I forget the name.
I can't answer that question. The complaints go to TPD. And then
so maybe
it's
this
a
is a Ms.
criminal-
Johnson-Velez
the rest is a
question. I
criminal law.
apologize.
So Susan Johnson-Velez, Legal Department. So the noise complaints, to the extent that a citation is issued by TPD, that's where those go. They're responded to by the Tampa Police Department. They're typically on the weekends or after hours, and Tampa Police Department will issue a citation to appear in court to answer for the charges. So that's what happened with the noise complaint. The difference between that and the code enforcement case is for,
No. I wanted the difference between I call in, I complain about a noise complaint. How did it get to the magistrate? I guess that's what I'm not understanding.
So the noise complaint didn't go to the magistrate.
Yeah,
It went to county court.
Okay,
Over
so
at the Edgecombe Courthouse.
So why did only one go to county court and not the 158 others? That's what I'm trying to understand.
I don't know if all of the other complaint calls, if there was a citation issued.
Okay, and what's the difference between just a noise complaint and a citation? How do you get a citation?
Tampa Police Department has to issue a citation.
Okay. And
for
so
a noise complaint. In
so-
this case, in the case that forms one of the bases under which we're seeking suspension, the officer actually went and went as far, 2,630 feet away and could still hear the music. And so under the city code, you only have to be 100 feet away. So they were 25 times farther away than they had to be.
So then what you're saying, though, by and large, is that for these 159 other events, if the complainant had asked, they could have possibly issued citations?
Well, it's up to the Tampa police officer who responds to the call to determine whether or not they issue a citation.
Okay,
In this one particular case, they did. I'm not sure what happened in the other.
Okay, that was my question as to why one versus another. I just wanted to make sure that people understood that one of them went to court, but that doesn't mean there weren't 100 and some other calls. Didn't necessarily get to court, but were still a complaint. Okay, that is that. And then I had another question for you, ma'am. Do these events only happen on the weekends?
Typically on the weekends and holidays.
What days of the week?
So the ticketed concerts occur on Saturday and Sunday.
Okay.
They do have regular concerts that are not ticketed on other days, but we did not count those in any of the numbers that were presented.
Okay.
To my knowledge. Could I answer a couple of the other questions? Am I allowed that you have asked?
Sure. If you feel like you can answer them, I'm happy to get your response.
Okay. I have three.
For the record, objection. We're hearing a lot of tests for the record. Can I be recognized?
Yes, well, for the record, Mr. Chairman.
Elise Batzel-Stearns Weaver. We're hearing a lot of testimony about Tampa Police Department. There's no documentation other than secondhand documentation from someone not in the Tampa Police Department So from a evidence standpoint, I just want to point that out for the record. If that's going to be part of your consideration, I would object to that.
Well,
line of
I
questioning
appreciate that,
information.
and actually, it's not. That's why I was trying to make the clarification, so I appreciate that.
Understand, I'm just putting that on the record.
I will make sure I do not testify about, for TPD. But you do have someone in the audience who was at the court case on the noise violation. So you may be able to get much more information about that if you were to ask. Also, it was asked whether there was was this a surprise? So this complaint did go in, and that has been there and something that the city has been working on. But Chicago representation for M2 came down, and they were part of the special magistrate FDN hearing, based on my recollection, when we had that prior to that decision coming in front of city council as well. So just a little bit more context about how long they've known. And I was there, I testified. They're very aware of the issues at that point.
And then I had one more question for you based on this slide. So you said the formal decision question was entered right after the first complaint on 6/14/22. Is that what that's showing? The gray triangle, the first gray in Q2.
Correct.
Okay.
There was
And-
a request, sorry, can you ask
No,
your
go
question
ahead,
again
yes,
so I
sorry.
make sure I am answering that correctly?
My question was, that was when they put the question about the formal decision in, correct?
That is when they first made their request. The affidavit wasn't sent in until August. So there was a delay on their end, but that is correct.
Okay, and so there was another one. I believe from your testimony earlier, you talked about the fact that there's also a change of land use possibly involved in this, or was that Ms. Johnson-Velez? No?
I think that may have been another
Okay.
person, based on historical patterns of the property.
Okay.
That could potentially stop future
Okay,
actions
okay.
here and enforcement that we've seen.
I apologize then, I misheard, but thank you very much. Those are my questions.
Councilman Miranda.
I just want to clear up something in my mind, Ms. Velez. Doing this whole thing, going back to 22, is it the same owner that had the same liquor license?
Yes, the owner, excuse me, M2 Tampa LLC has been the owner of this property since August 11th of 2021.
And the license was his license?
That's correct.
And where does the group of the band come in?
Pardon me?
The group of the band, they had nothing to do with it, were they just hired musicians?
Well, they have concerts with DJs and so forth. So that's a separate entity. But everything that separate entity, Mr. Piper, a separate person or production company, has done has been with authorization from the owner. Everything that's been filed with the
And then another question in
city.
my mind, anytime anybody buys something, they look at the performer of that business for 5 years. I'm not talking about this case, I'm talking in general terms, 3-year performance, 5-year, 10-year performance, before they buy something. So I don't know, I'm just talking to myself, I said, I don't quite understand the whole mumbo jumbo here, but I can't talk about how I feel.
Anything else, sir?
That's it.
Councilmember Clendon.
I want to beat a dead horse. So is it possible for you to clarify? So you highlighted paragraphs D, L, and N. Can you summarize the evidence that you are using specifically that correlates with D, L, and N?
Yes, sir, I certainly can. So D, which is, let me just flip to the, operating the establishment in a manner that repeatedly or on an ongoing basis has negative secondary effects on surrounding property. So the evidence there is the testimony that you heard from all of the neighbors in the area who have come to testify this afternoon. That established negative, or we believe that established negative secondary impacts from the establishment. Number L, been convicted of the exterior maximum sound levels as provided for in Chapter 13, we have the court finding after a trial in January 2024 of a violation of section 14-154, which is part of the city's noise ordinance for an officer being able to hear music from 2,630 feet away. And then finally, we have the 3 code enforcement cases, the 3 code enforcement orders that found a violation of, for failure to obtain or failure to comply with a condition of approval. That is failure to obtain temporary special event permits pursuant to 27-282.16 of the city code. And I would add that Ms. Batzel said that they weren't contesting any of the evidence. So it is uncontroverted that all of those are facts. No one's contested those. Those are all actually established facts at this point that they have essentially admitted to.
So in speaking of law, Mr. Shelby or Ms. Johnson, if both sides have stipulated to that fact that these violations have occurred, then we really can bypass the finding of fact that we've got a violation.
No, if I can, may I?
Yes,
Specifically, that is exactly what you have to do.
But if both sides have stipulated
Then
that the
that has to be
violations occurred.
then that could be one of the bases of your decision,
Mm-hmm.
but it still has to be a formal decision, a decision formally made by this body, by motion and vote of council, for a finding before you can even contemplate
I guess this is part of where I'm confused, because I'm going, okay, we're in agreement that these things have happened, so why are we beating this dead horse?
It's council's pleasure,
Okay.
whether, you've heard, it was rather clearly stated.
So would it be appropriate for me to say, to make a motion that we accept that its violation has occurred and move?
No, you can't, no, that's not the motion. Frankly, at this point in time, there is an opportunity for rebuttal by Ms. Batzel, and I would suggest that you hear out all of the argument from staff, from the city legal, and if there's anything that needs to be clarified by city staff, and then allow Ms. Batzel for that period of rebuttal. I don't know whether back and forth sir rebuttal is going to be.
Well, I have one more question before we move on.
Yeah.
And I'm going back to this pending litigation. And because isn't it part of, because of the stipulation on the site plan? And that is based for special events? Isn't that what is being pending? So if you didn't have special events, wouldn't all of this just that particular end be wiped away?
No, because there are orders from the city's code enforcement special magistrate finding a violation that were not appealed, and so those orders are final. That is what forms the basis of a portion of this case. So it has nothing to do with what might happen in court with that case. It has to do with final orders imposing fines in the amount of $31,500 for failing to get a temporary special event permit.
But isn't that temporary special, what is what's on the site plan?
The requirement is on the site plan. They failed to do that. They were found in violation for failing to do that, and then no one appealed those. So you're in essence agreeing with that if you don't appeal it. If you have a chance to appeal it and say this is not appropriate, but those orders are final, and that is not the subject of the pending court case. None of those code enforcement orders are the subject of this pending code case. Furthermore, I'll reiterate that Ms. Batzel has agreed to the evidence, is not contesting any of the evidence that's been submitted for you.
Okay.
So I would propose the reverse of what Mr. Shelby suggested, since the city has the burden here. I would ask that Ms. Batzel be heard first on rebuttal, and then if I may close out the case.
Okay. No. Ms. Batzel, you have your time for rebuttal. 2 hours.
Elise Batzel, for the record. Just a couple of points. I just want to clarify, Ms. Johnson-Velez did say that everything that had happened was with the authorization of the owner. I'm sure that's not what she meant. I just want to clarify for the record that with the exception of the formal determination and the agreement that they had to hold the concerts, not everything was with the authorization of the owner. I think that's really important. I think it's also important to consider when you're thinking about exactly what you're making a decision on for this notice of intent. It is the old violations that we're talking about from 2021 and 2023 that formed the basis, and the the noise violation. You heard a lot of testimony about other things today, but what you're charged with informing your decision with respect to the suspension is what is in the city's case with respect to the basis, those specific basis and we have stipulated to those facts. We provided you with the additional information so that it might inform your decision about the length and the scope of the suspension, should you choose to impose such a suspension.
Thank you very much.
We appreciate your time and consideration.
Thank you very much. Now, the city would like to make closing remarks. Ms. Johnson-Velez. And then we'll ask for a motion to close and a motion. Yes, ma'am.
Susan Johnson, Velez Legal Department. Council, I think we've gone over the evidence in quite a bit of detail, so I won't reiterate that. But the city believes that we have shown, clearly shown, based on uncontroverted evidence, that there is, in fact, a violation of Section 27-318 based on Section D and Section L and Section N. And I would point to you to page 5 of 6 of the copy that I provided you of Section 27-318 with respect to the matters that council should consider when determining the length of a suspension. The city, again, has asked for the maximum 30-day suspension, and council shall consider, you can see it listed in the middle of the page, the gravity of the violation, which I believe that we have shown that they're pretty grave violations, particularly based on the secondary impacts that have been experienced by the property owners over a number of years. Any actions taken by the violator to correct the violation. Up until this point, we haven't had any sworn testimony by a fact witness of any steps that have been taken to correct the violation. And then previous violations, again, this whole case is based on previous violations. And the fact that despite those prior findings of violation, the types of activities upon which those were based have continued on now for the past 2 and 3 years. And so based on all those, the city would request, again, imposition of the maximum. First of all, a finding of a violation, this being a first violation, we would request imposition of the maximum penalty of 30 days. Thank you very much, Council.
Yes.
Before we close the public hearing, there were conversations about timing from some of our, from some of the folks who provided testimony. Does the city have a position on that?
When the suspension should occur.
Eric Cotton, Development Coordination. The city does not. You understand where the neighbors are coming from, though, but that's the purview of council.
Okay, thank you. I just wanted to, so we didn't have to reopen.
Thank you very much. Can I get a motion to close? Motion to close from Councilmember Miranda, second from Councilmember Henderson. All in favor? Aye. Councilmember Hurtak, Mr. Shelby, before I go to Councilmember Hurtak.
Martin Shelby, City Council Attorney. Again, I'm going to direct your attention, for purposes of your discussion, to tab A1, and particularly to page 4 of 6. Tab A1, 4 of 6, page 4 of 6, revocation or suspension of sales for cause. And for the purposes of the record, I'm going to read just a portion of section 27-318. It says, the City Council, after conducting a public hearing as provided in the City Code, is authorized to suspend or revoke the ability to sell alcoholic beverages from property which has been previously granted an approval. In order for the City Council to suspend or revoke, it must determine that the property owner, holder of the alcoholic beverage license, operator of the establishment, or any agent or employee thereof have been found to have violated or have been convicted of any one of the following, one or more of the following. And again, as you've heard, what was highlighted was sections D, L, and N, and I'd ask that council not contemplate any penalty until this determination has been made by motion and vote of council.
So the first part is that there was or was not a violation, and then we go to the penalty motion.
Yes, two motions, and the first one should be a finding, and council, again, you know what the bases for those can be.
Thank you very much. Councilmember Hurtak, you're recognized.
Thank you. Oh, yeah, go for it.
Go ahead.
Can you
Wait with your mic.
Attorney Shelby, can you exceed the 30 days? You can go up to 60 days.
We're
on
not
the
going
first
there
one.
yet.
Yeah,
That's
we're not going there
exactly
yet.
That's exactly our point.
Yes.
Oh, okay.
You're at the first decision point, a threshold question that has to be addressed by motion and vote, and a finding of fact by city council.
Okay.
Councilmember Hurtak.
So I'll try and see what people think. I find that the Godfrey Hotel and Cabanas at 7700 Courtney Campbell Causeway has violated and/or been convicted of D, operating the establishment in a manner that repeatedly or on an ongoing basis has negative secondary effects on surrounding property, including but not limited to violations of city code, ordinance, or state law related to noise, parking, or trash and debris after having received reasonable notice to terminate or correct any condition that is in the violation of such code, ordinance, or law. Subsection L, been convicted of the exterior maximum sound levels as provided for in Chapter 14, noise, specifically the January 24th, 2024, or the January 2024 trial that is dealing with Section 14-154. And subsection N, the violation of any section of Chapter 14 or 27, any condition, limitation, or restriction imposed by City Council or the zoning administrator at the time of approval, or any other section of the Tampa City Code relating to alcoholic beverages, most notably the 3 cases previously decided by the magistrate.
So this is a motion of a finding of
Just
violation.
finding a violation.
Yes.
I do have, once someone seconds, I have another possible, well, no, I'll just wait there.
We have a second from Councilmember Vieira. This is the motion that needs to be made before anything else.
And if there's any additional findings that you want to put on that in the record to supplement that. For instance, other things you might have.
We have a
discussed.
motion and a second.
I would like to make
Councilmember Condon.
I'd like to make a motion to divide the question and have section N as a separate vote, because I'm comfortable voting on the first on D and L, but I still don't believe I've heard enough evidence to suggest, to convince me that N is applicable here. So if we could have 2 different votes, I'd appreciate it, because I could vote with you on the first 2, but not the third.
Well, but the issue is, we have to, then we would have 2 separate penalties. I don't think that's appropriate, but I understand your issue with N, and I'm happy to take N out because I think D and L on its own merits. Now, I don't know if Ms. Johnson-Velez agrees with me on that, but
If I can. Number 1 is, this was the notice of violation, and these were the 3 cited. I guess factually, if you wish to do it separately, you can. It is up to, I guess, the maker of the motion discussion of council. Certainly, if there's a disagreement among council, this does not require a unanimous vote. It requires a
It just seems
majority.
like it'd be a lot cleaner, even for defensible. if
It
we
might
just-
be, it might be less clean if you actually have to create a more convoluted record with multiple violations.
What if we just had one motion and
you
just
want-
had the 2 and not the third?
Whatever council,
that's
let's
what
find out, let's
Councilmember
find out where we go
Hurtak
on this. Unless do you have a legal opinion, or you want to stay out of this?
we have to open the
I don't
hearing
think you,
again?
well, this is, no, they're representing the city, let's.
Yeah, you're fine. Let's
Yeah.
go. Yes, Ms. Johnson-Velez.
I think council, it's within council's discretion to determine if you've heard sufficient evidence, and again, none of the evidence was controverted, and the property owner has stipulated to, they're not contesting any of the evidence, any of the bases, anything, so.
Okay, thank you. So yeah, I will not take your amendment.
We have a motion and a second, and Councilmember Miranda.
Louis Vieira.
I'm sorry, Councilman Vieira with the second. Yes, sir, Councilman Miranda.
Regarding the motion, I'm fine with it, but I don't think the section of law and the specific of the law was mentioned. Does that fall under 27-318?
Yes.
Yes.
Did she say that?
Yes.
No, I read that.
No, I
but-
didn't, so
No, you
thank
didn't.
you. I appreciate it. Yeah.
Thank you, sir.
So if you could clarify it.
Yes, I will accept Councilmember Miranda's suggestion to add that it is section 27-318 subsection D.
D.
Sorry, nope, sorry.
Yes, ma'am.
Section 27, 318, C1, D, L, and N.
Oh, I'm sorry, C1, D, L, and N.
Is the seconder of the motion still good? Yes, sir. Councilmember Vieira with the second, we'll do a roll call vote.
Miranda,
Yes.
Carlson. Yes. Hurtak.
Yes.
Clendenin,
For the above stated reason, no.
Henderson,
Yes.
Vieira.
Yes.
And Maniscalco.
Yes.
Motion carried with Clendenin voting no.
Councilmember Hurtak, did you have a follow-up motion?
I-
This now goes to the penalty phase.
Yeah, I did, and this is gonna be controversial, so I'm just gonna put it out there.
Wait, Mr.
I
Shelby?
bet you won't be for
Sorry to interrupt you, but I want to bring you back to the code upon which you must base your decision. And again, reading from 27-318, and I don't remember which C or whatever it is, I believe it's C.
Yeah.
C, it would be following N, so it would be C. City council may suspend the ability to sell alcoholic beverages for up to 30 days for the first violation, answering your question.
Right.
60 days for the second violation, and 90 days for the third violation. Upon the fourth or subsequent violation, City Council may consider revocation of the approval to sell alcoholic beverages. In determining whether to suspend or revoke an approval to sell alcoholic beverages, City Council shall consider A, the gravity of the violation, B, any actions taken by the violator to correct the violation, and C, any previous violations committed by the violator.
Councilmember Hurtak, go ahead.
Thank you. And this is the reason I chose this, because I appreciate Mr. Shelby mentioning section 318 subsection C after, C1. After the, in the area talking about what the, what we can look at to determine this. The gravity of the violation I find to be very egregious, because this continues to happen over and over and over again. The slide where we saw all of the different events that are happening and the photos of how many events are happening over and over again. And the actions taken by the violator to correct the violation, at the very last minute, the owner decided to come in and try to do something about it. And any previous violations committed by the violator, and those we've already taken into record. So my suggestion is a 30-day suspension, but for 2025, for the weekends only, for March 15th through 16th, the 22nd through 23rd, 29th through 30th, for April, the 5th through the 6th, the 12th through the 13th, the 19th through the 20th, the 26th through the 27th, May, the 3rd and the 4th, the 10th and the 11th, the 17th and 18th, the 24th to 25th, and April 31st to May 1st, June 1st, and then June 7th and 8th, 14th and 15th, and 21st and 22nd. Because to me, if you're gonna wait this long and just blame someone else for it, you gotta pay somehow. And I think taking them on the weekends, because we can't guarantee that the DJ is not gonna continue. We cannot guarantee that. They just may choose a different DJ to come out, because I just don't believe that this owner has taken this seriously. They've come in front of us before, and to me, that is what I want. I want them to have all of these weekends to not have alcohol.
I can second that.
All right, we have a second. Councilmember Clendenin has
Can
his
I
hand up
say
for.
something, though?
Wait, Councilmember Henderson with discussion, Councilmember Clendenin.
The one thing about it just being only the weekends is the concern for spring break, because when it's spring break, it's a full week of young people partying, and so that kind of concerns me. But I'd rather just stick with this weekend thing, because that'll be very helpful.
Councilmember Clendenin.
Yeah, second, officially.
Oh, my. You had asked a question earlier, and I think the answer is with us. Like, how do you prevent this from happening? I think we have ambiguity, and part of the reason we're here today is because of ambiguity. There's a note on the site plan about concerts. What is the definition of a concert? What's the definition of a special event? I'm not clear that it's clear, and I think the city, we need to clarify that, and I think that without that clarification, it's difficult to hold somebody accountable for these things. And I also don't necessarily believe that it's our job to be above and above punitive, and which I think is your reaction to doing the non-consecutive days, which I don't even know if is in order. I mean, I don't even know if there's precedent for that. Is it legal counsel? Is there precedent for non-consecutive days?
I believe we have in the past, like, chopped it up.
Susan Johnson, Velez Legal Department. I don't know that council has done the suspension in that way, but there's nothing in the code to prevent you from doing that, so it would be in
Because
council's
there's
discretion.
also impact that you have on not only the business of, a viable business is providing the economic, part of our economy. You have employees that work there. And I know I've brought this up in the past, that you have employees that this is dependent upon their salary and their income that this impacts. This impacts a broad range of folks as well. So I think that we have to consider, I think one of the things, and Mr. Shelby highlighted, that within our code, that we shall consider the gravity of the violation and any action taken by the violator to correct the violation. The owner of the property, which was not the concert promoter that has created the nuisance, the owner of the property came in today, has notified us that they've already taken the action to terminate their agreement with the promoter. So I think that's a big outreach, and I would think that the neighbors would say, do you want a pound of flesh or do you want a solution to the problem? And so, a pound of flesh or a solution to the problem. And I think what we should be looking for is a solution to the problem. And I think what's been presented today is a solution to a problem. And, can we do something? Yes. I think the applicant even, gave us options that were reasonable to exercise a penalty as far as, times of, 15 days of inside, only to be able to keep the restaurant going, and it's a hotel, and I don't know how you can operate a hotel. Think about all the maids. These people are all making low wages that are working here that have to function as a hotel, and I don't know how you can operate as a hotel without having this type of a license. So we shall consider the violation and also any of the corrective actions that are taken. Again, they came before us today, said that they're willing to go and they've terminated this contract, this agreement they had with this promoter, and I think we can clean it up for future of define what a special event is and define what a concert is, and I think that's within our purview of doing for future reference, so that we don't have this problem again.
Henderson,
Thank you.
Carlson, Hurtak.
Well, I have to kindly, respectfully disagree with you. I think that a hotel can operate without somebody having a drink, that's for sure. I do it all the time. And also, I don't think that that their side gets to decide what the punishment should be, and it should fit within parameters that are fiscally convenient for them. We kind of got into that the last time in terms of focusing on the livelihood rather than the infraction. And so the hotel, what is a fact is that the hotel can still run without alcohol being served. And that's what that is what is being penalized right now is their liquor license, correct? Not necessarily the hotel. So I don't want us to blame it on that, and we shouldn't have to, rely on that to be a decision. And I do agree that it should be the weekends, because the infractor should not be able to decide what the punishment should be, when they've clearly admitted to the fact that, they are not arguing with all of the points that have been made.
Carlson, Hurtak. No, the hearing is closed.
I have a point of order.
If I can,
Yes.
Ms. Batzel, do you have an objection you wish to make for the record?
I do.
May she be heard, please?
No,
The
we
hearing is
closed.
closed.
We closed the hearing.
That may be true, but for
This is
the
an
purposes of
evidentiary hearing.
procedural due process, she is required to make an objection for the record. That's her prerogative and her duty, frankly.
I have an objection for the record with respect to the weekends. Under Rinker Materials Court v. City of North Miami, 286 Southern 2nd, 552, which was determined by the Florida Supreme Court in 1963, it says that your regulations, your land development regulations, such as those that you're considering tonight, are in derogation of private property rights. And if there is any type of ambiguity as to whether you can or cannot, they must be made, that decision and ambiguity must result in the landowner's favor. And so therefore, I do believe that you're acting without the scope of your authority under that case.
You wouldn't happen to have a copy for the record or for me?
I don't.
Okay.
Thank you very much. Carlson, Hurtak.
I agree with Councilmember Clendenin. 30 days, I don't know the business of this operation, but they've already, per B, they've already shut down the, this particular promoter. Hopefully they'll continue not having the loud outdoor concerts. That's the main thing that everybody wanted. There's a longer term issue and solution that hopefully Ms. Batzel will help them with to prevent this from happening in the future. But they do meet the gravity test that, based on the testimony from the citizens, it was pretty egregious, and the attitudes at least as presented were not good. And we had evidence of previous violation, which we heard before. But we can see now, at least as of today, the owner is trying to correct the situation. 30 days, we have a choice between, I think, 0 and 30 days. And we did have a case like this a few months ago. But for any kind of establishment, losing their liquor license, even for a few days, is a very expensive thing. Losing it for 30 days is very expensive. I don't know what their business model is, whether they have more business on the weekdays or weekends. If they're mostly a business crowd that comes in, then they may be happy that we're taking away weekends. We don't know that because we don't know their business. I would say for simplicity's sake and for consistency, we should give them a set amount, like 30 days. But the other thing here, I know it's a long process and the community has unfortunately had to go through a lot of turmoil because of this, but we are 1/4 of the way toward them having their liquor license revoked completely. So if this happens 3 more times, this is the first step. The significance of this is not just whether it's 15 or 30 days or whatever, it's that this is the first of 4 steps where they could have it revoked completely. Most people don't want that to happen, and in the other cases, without mentioning names, we can see great changes in the way businesses behaved and collaborated with their neighborhoods after something like this happened. So hopefully, with a basic kind of penalty, they will do that. If the proposal is to go on weekends, I'm going to vote against it. I'll vote for 30 days or less consecutively. Thank you.
Councilmember Hurtak.
Thank you. I disagree with the 2 gentlemen that sit next to me. I mean, the owner's known about these issues. This has been 3 years of neighborhood complaint, years. And this is the biggest tell of all to me. They got this notice on May 31st. When did they decide to sever the relationship? Yesterday. It's been 3.5 months. So they let the concert promoter finish their season instead of absolutely cutting it off when they got the notice. And that's the big thing to me. To me, that's the egregiousness. It's not, oh yeah, we're gonna cancel the agreement with the promoter. You should have done that on May 31st. If you were really serious about stopping this, that's when you would have done it. Instead, you waited till yesterday because they already got a 30-day extension on this. They came to us and said, oh, our owner won't be available, and so we were nice enough to move it. If we had known at the time that that was going to be moving to after their concert time, then I might have changed my vote, but I didn't know that. So to me, that is the egregious part of it is, and you know, so if you don't want to, if this doesn't go through, my other recommendation would be to do spring break, the month of spring break, which would be March.
Councilmember Clendenin.
Yeah, I have a problem with being this like, it's not just good enough to fix the problem, but we have to be extra punitive in this. I think that part of the thing, but I think part of it, I think when I would say that we didn't have evidence that said about what knowledge the owner of the property had, was never presented as evidence to us competent substantial evidence to us as to what degree of knowledge they had about what was happening. Clearly, if the promoter was standing before us, we'd have a different answer to that question. But as far as the property owner, the owner of this liquor
We
license.
did get the answer. I asked Ms. Johnson Velez if they get the notifications, and she said property owners receive notifications.
Well, I don't know, we did not have really competent substantial evidence of what the owner actually knew about the degree, how many of the violations, I mean, all of the details of all of this. I didn't hear it in my listening to the testimony. I think we should look at this again. I think Councilman Carlson said, this is something that owners don't want. They don't want this first strike on their record, because then 3 more and they're done. So we don't do this very often, by the way. I mean, this is a very rare occurrence for council to go this far on liquor licenses. I think providing anything, even if it's 1 day, if it's 10 days, 15, or even up to 30 days, any one of those is really equals. It's an equal part, because it's the first step of a 4-part process. So I think because the owners came in today and took proof positive steps that would rectify the situation and make the situation better, I think we need to take an IOU to tighten up our definition of what a concert is. Because I also disagree, because I know you use the word concert. I know the neighbors talked about concert. I think that's still out in the air of what a concert is, and what does a DJ. Is a DJ a concert? I think that's subject to discussion. Special events, again, I think we need to tighten these definitions up so we have a clear understanding. But if you look at what we shall consider, the gravity of the violation, any actions taken by the violator to correct the violation. Previous violation, the one noise complaint, for sure, 100%. I agree with that. That's why I want to vote with you on the first 2 violations. But I think offering a 15-day suspension effective, within the next 30 days, I think would be adequate as a first step towards the 4-step process.
Councilmember Vieira.
Thank you very much, Mr. Chair. So, the issue of whether or not the property owner got the notice, to me, is not quite as relevant as the fact that the property owner is obviously very, I want to use the word savvy, sophisticated. In other words, they're equipped with sufficient knowledge and experience such that they've known or should have known that something of that nature is here. This gentleman, seems like a fine gentleman, came down here from Illinois, the land of Lincoln, and retained one of the best law firms in Tampa for this. So obviously they're savvy, sophisticated, et cetera. For me, going on weekends is a bridge too far. I do think there is something there where we should have a penalty that is more than something cursory. I'm closer to 30 days than I am. I'm fine with pushing it sometime in the future, but pushing it towards weekends, I think, is a little bit too, the word punitive has been used. I do think that is overly punitive at this stage, but I am for something harsher than 15 days and something that's being pushed into the future. I'm fine with that because, again, this property owner, whether or not they knew about this, they should have known about it. And again, they have great lawyers, obviously sophisticated, et cetera. When you do business and you own property like this and situated in this part, you're equipped with certain knowledge, whether or not you choose to access it or not. You're equipped with certain duties, I would suggest. But again, something on the weekends for me, I just think that's too, I hate to use the word punitive, but a little too much.
We have a motion and a second. Councilmember Henderson.
Thank you so much. So that if we go to just the 30 days of March, then we remove the cause of action. Wouldn't we do that? Avoid that in a sense?
Potentially, because it would be consecutive is what you're saying.
Right. So, we could amend it to just the 30 days in March so we can get to 4. And also the other thing.
I would like to just have the vote anyway.
Wait, let her
personally,
finish. Let her finish. And when I recognize you, you can respond. Please finish.
Okay, thank you.
Thank you.
Okay, Chair. And the other thing about it too, this is our 3rd time, dealing with a liquor license situation, and so the thing that kind of concerns me, and I don't even know if this should apply, But when it was in East Tampa, we
Wait a
did
minute,
not concern
excuse
ourselves
me,
with the
I'm gonna
economics
interrupt.
of the situation.
Okay, I'm just gonna.
You know, I mean, we're not, like, we're talking about economics and financial loss to these larger businesses or savvy, sophisticated, high-paid lawyer businesses. And I don't want that to be, you know, a factor. And let's just stick with what's already been admitted. And so, but I want to get to 4. And if we get to 4 votes, it sounds like we could get there with 30 days consistent.
So what are you doing with regard
So
to
if
your
we,
second?
you know, I don't know, that thing that Alan likes to do, like amend it or something?
Well, my question to you-
Substitute motion?
Well, my question is, you are the seconder of the motion?
I am the secondary of the motion.
So what is it, do you still stick with your second then, is my question? In other words, a motion requires a motion and a second. You seconded that, you seconded her motion initially.
Yeah, I did, but,
You can withdraw your second.
yeah, and then substitute? Oh, no, how would that work?
Then it would be a clean slate.
The motion would die, and it would have to be a different motion. Councilmember.
Okay, well, let's see what Mr. Miranda has to say.
Councilmember Moran.
Let me say this. How did that $31,500 on 123 that's in the court, how was that earned? It was earned by what? By having a violation where? On the weekends. So I'm not opposed to having it on the weekends. That's what happened, that's what history tells me, and I'm not here to, you can vote any way you want. I didn't want to take a vote, because we're talking about something that ain't going nowhere. You know, how did it happen? It didn't happen through osmosis. There had to be somebody there giving a ticket on a certain date, at a certain time. That's all I can say. Thank you.
Okay,
Thank you very much. Does your second still stand?
yeah, I'm gonna keep it and see what happens.
All right, so we have a motion from Councilmember Hurtak, a second from Councilmember Henderson, and let's do a roll call vote.
Henderson,
Of course.
Vieira,
No.
Miranda.
Yes.
Carlson. Hurtak,
Yes.
Clendenin,
No.
and Maniscalco.
No.
Motion failed with Vieira, Carlson, Clendenin, and Maniscalco voting no.
So I'll, before a motion gets put up, if it was mentioned about spring break 30 days consecutively, is something that I would support.
And that's exactly what
I'll make a motion.
Councilmember
that's-
Clendenin.
I'll make a,
I had my light on.
She had a light on first.
All right, Councilmember Hurtak.
So I'm making a motion to then do the 30 days
Second.
for March 1st through March 30th of 2025. Or, I'm sorry, 30 days has September. March 31st. No, you're right, it's 30 days, so
March
it's
1st to the 30th. Yes.
1st through the 30th,
Yeah, second.
2025.
Yes, ma'am.
Susan Johnson,
Councilman
Les Legal
Velez.
Department, just for clarity, could we say midnight?
Yeah.
I apologize,
March
midnight
to
on, actually, can I borrow someone's?
What you need?
Yeah, I need the calendar, thank you. So I'm gonna say March, because I don't have a phone up here, I'm the only one.
No, don't admit that publicly.
March 1st through March 30th, 2025. At midnight,
Midnight on March 1st?
no, midnight on, so it would be midnight, March 1st, which would be the
Saturday.
first day, or the first minute of March 1st, right?
Yeah, and that starts in the.
Okay, so 12 a.m., March 1st, midnight.
2025.
2025 to 12, or
11:59.
to 11:59 p.m., March 30th, 2025.
Second.
We have a motion and a second. Councilmember Clendenin, Councilmember Carlson.
And my rationale for that is because that is when the concert series has begun for the last 3 years.
Okay, Councilmember Clendenin, Councilmember Carlson.
So, gosh, I'm having a hard time intellectually getting past this. Is what's the purpose? Your supposition, you'd have to have a leap of faith of information that's not in evidence of, like, what does that produce? I mean, because that's not within the confines of what it's highlighted in code and law. And you're taking a leap and saying that you're guessing that that's going to be the worst time and what's going to cost them the most amount of money. But again, that's not in evidence either. Well, I think because of the outside concepts, but the owners of the property have already said that they've discontinued the use of that promoter. In evidence, they've said that they would now, if they're going to have events like that, they would apply for special event permits, so that they're going to go in and check off all of these boxes that hadn't been done in the past. So for the reference to those concerts, that was in evidence. That was something they came before us under sworn testimony and said that they would do these things. So I don't know what it just seems very arbitrary to me to reach in that far into the future to impose a penalty. Again, and I'm under the feeling that, again, this is a business of a hotel with a lot of people working in it. And can we accomplish the same thing? Again, the problem is outdoor music. Can we do the same thing with what they had presented and say, let's restrict alcohol sales to inside, which is clearly defined? I mean, I think my 4-year-old granddaughter could tell you what the difference between inside and outside is. And I'll still allow them to function as a hotel with all of the benefits and services of that, and restrict the profit and what they would make from outside liquor consumption.
Councilmember Carl.
Yeah, part of what you said was just exactly what I was going to say. I think the best state for the residents in the future is that this hotel figures out a way to operate and be profitable as a hotel resort and without concerts outside. If we limited the penalty to just the outdoor areas, that would give them 30 days or whatever to experiment with a business model that doesn't include the outdoor areas. And hopefully they would find that that's a great business model for them, and they won't need concerts anymore, and we won't have to be back here again. It seems to me that it'd be a lot more effective to just do it outdoors.
Councilmember Vieira.
I want to make sure before I was going to call the question so that we can vote on it. I don't want, if no one else has to say anything, then I won't call the question. But
Councilmember Miranda.
Just one thing.
then after that, I'm going to call the question.
All right.
What does a promoter mean? Anybody can be a promoter. You can get another name and run it as promoter. I'm not saying they are, don't get me wrong. You can get a promoter, say, no, this is, he used to have it, but now he changed his name, and now it's ABC Promotion instead of CBS Promotion. And you do the same thing. I'm not saying that they're doing it, I'm just saying this is an example of law. There is nothing that I know of that identifies a promoter. Promoter is just a name.
I'd like to make a motion to amend the motion to include only outdoor areas.
Is there a second? Second from Councilmember Carlson.
I do not accept the amendment.
Councilmember Clendenin has a motion. Mr. Shelby.
Discussion on the motion?
Well, but Mr. Vieira had said he was going to call the question after his comment. So,
Yeah.
Let me, if I may, I'm going to go ahead and call the question. If this fails, then. And let's.
Point of order, we have a motion and we have a second on the floor that the chair should call for a vote on that amendment.
Mr. Shelby.
The question is whether the chair views Mr. Vieira's statement as calling the question.
Yeah, I would accept what Councilman Vieira said.
Was there a
Because he said
second?
it first.
Was there a second to call the question?
Second, yes, that was from me.
Point of order, then he relinquished the floor. He relinquished the floor for subsequent discussion. And then I made a motion to amend the motion, which would be in order, and that motion was seconded.
How about this? May I, Mr. Chair?
Yes, sir.
I'll call the question on Councilman Clendenin's amendment. I don't plan on voting for it, but again, I just want to move this thing forward.
Mr. Shelby, I would accept that. I will accept that.
So what is your decision?
I will take Councilmember Clendenin's motion with the second, and we can vote on that first. This is to restrict it to outdoor only.
Let's vote on this, let's vote on
Okay,
something.
let's do
All
it.
right, take a roll call vote.
Miranda,
No.
Carlson,
Yes.
Hurtak,
no.
Clendenin,
Yes.
Henderson,
No.
Vieira,
No.
Maniscalco.
Yes.
Motion failed with Miranda, Hurtak, Henderson, and Vieira voting no.
We now go back to Councilmember Hurtak's original motion, which has a second.
We go back to call the question. Just-
I don't need to,
It ends
by
debate.
operation of what we're.
Thank you very much.
I just want-
Councilmember Hurtak has a motion.
Second.
There's a second from Councilmember Henderson. Roll call vote.
Vieira,
Yes.
Miranda,
Yes.
Carlson,
Yes.
Hurtak,
Yes.
Clendenin,
Yes.
Henderson,
Yes.
Ed Maniscalco.
Yes.
Motion carried unanimously.
Thank you very much. Would anybody like a 5-minute recess? Thank you very much. I'm on 3 hours of. Before we start with item 66, I just want to bring up, there's a lot of back and forth chatter and conversations across the days that's very distracting. Out of respect for everybody in the audience and up here, if we could just limit all that so we can all stay focused. Item number 66.
Emma Gregory, Assistant City Attorney. This is a proposed first reading for an ordinance amending certain sections of Chapter 22 dealing with streets and sidewalks. These deal with benches, and these proposed changes will streamline administration of permitting and the permitting process for applicants, and it also brings our bench requirements, like the actual technical requirements for the size of the benches, into ADA compliance and into compliance with the public right-of-way accessibility guidelines, which are under the umbrella of the ADA. So we're just asking for approval or first reading
All
today.
right. Any questions or comments from council members? Councilmember Vieira, would you like to read item 66?
Sure, if I may. Thank you, sir, Mr. Chair. Ordinance being presented for first reading consideration, an ordinance of the City of Tampa, Florida, making revisions to City of Tampa Code of Ordinances, Chapter 22, Streets and Sidewalks, Article 1, Administrative Provisions, amending sections 22-116 through 22-121, and sections 22-123 through 22-128, and sections 22-132 through 22-133, providing for repeal of all ordinances or parts of ordinances in conflict or with, providing for severability, providing an effective date.
Do we have a second? Second from Councilmember Clendenin. All in favor? Aye. Any opposed?
Motion carried unanimously with Hurtak and Henderson being absent at vote. Second reading and adoption will be held on October 17th, 2024 at 10 o'clock a.m. in Tampa City Council Chambers, 315 East Kennedy Boulevard, 3rd floor, Tampa, Florida, 33602.
Thank you very much.
Thank you.
All right, item number 67, the administration update is actually going to be 72. What is the city doing regarding the passage, or regarding the CIT? I see Andrea Zellman here and Mr. Adam Smith in the background. So, Ms. Zellman, go ahead.
Yes, and we'll both speak. Andrea Zellman, City Attorney. I just wanted to explain what the legal parameters are that govern what the city can do, and then Adam will talk about what the city is doing. And I want to be clear with regard to the community investment tax. I want to be clear that we don't know and we cannot speak to what others outside the city may be doing. We can only speak to what the city can do and is doing. So I just wanted to make clear that there is a Florida statute, 106.113, that governs what local governments can spend city funds on with regard to elections. And it does limit what the city can spend money on. And one of the recent changes, in the last few years, is, for example, a city government or any local government can no longer send mailers, flyers, whatever, directly to voters about an item that's on the ballot. So if you remember, in the past, we've put things in people's utility bills or whatever, and that is now prohibited. So I just want to make sure that the city cannot spend funds on something that advocates for the passage of the referendum. However, we can spend it on things that provide factual information, although again, those cannot be sent directly to the voters. That was the recent change. We're also prohibited from using city money to pay like an outside company to do political advertisements. But again, the city can spend money on informational flyers that are handed out, for instance, at a town hall or a neighborhood meeting, as long as the flyers are limited to factual information. We can provide factual information in response to a question. We can host a public forum and again provide factual information. And that, what I've just described, is what city money can be spent on by statute. I do want to note that, again, while city staff, city employees can't advocate for the passage, all elected officials can. So the mayor and every one of you can publicly state that people should vote, whichever way you believe they should vote, on this. You can say it on, in any format you want to. And that reminds me, I left out one thing the city can do. We can post factual information on our website.
Okay.
So I just wanted to explain that those are the guardrails that the city is operating under, and now I'll let Adam explain to you what the city is doing within those guardrails.
Thank you very much. Mr. Smith?
Let's see if I have that. Does that work right? Great.
Yes, it'll come.
That's just a sampling of some of the stuff we're putting on social media pretty regularly. We sort of have to balance, we're doing it multiple times a week, just pretty plain vanilla, just the facts kind of material to let people know what it has been.
Can you zoom out just a little bit?
Do I do that?
Yeah, so what I see here is the social media post, but they're highlighting what CIT does.
Yeah, so we talk about what does it fund, the broad categories that it will fund, where does the money come from. The mayor on her account is a little bit more aggressive, or she actually advocates for it and says this is essential. But, we also work closely with the county communications folks, so we sort of jointly put together, this is their ballot initiative, but we together work closely to do a website that identifies the projects, both on the city site and their site. And then just today, we ordered, I would call them campaign-type signs that will be going, one of the things that, for those of you who've been in Pinellas, I think a lot of people think what has made the Penny for Pinellas so successful and popular there is that everywhere you go, you see paid for by the Penny for Pinellas, and people see it. And I think the goal that we've talked about both with the county and the city is, let's do that, if this passes, let's try to do that going forward, is to mark our projects, whether it's a temporary paving project or a new rec center paid for by your, I think another question is, do we want to keep calling it the community investment tax? Tax is not a great word. I think we could probably do better after it's over. But, so we're going to probably we've ordered for now 50 yard signs that are going to be put in front of some of our projects saying paid for by your community investment tax around here. People are not really aware of it. We want to make people know there's as much as they can about it. The mayor started, some of you were at the West Tampa Chamber, you saw her touting it. She did a university club thing. She'll go anywhere and everywhere to talk about it, and you all could too with your neighborhood groups and whatnot.
You could put your half cent at work. There you go. It doesn't say the three-letter word. So I don't know. Councilmember Vieira, you asked to speak first. Councilmember Miranda.
Thank you very much, Mr. Chair. I appreciate that. And I want to be clear, by making this motion, I wasn't asking the city to spend any tax dollars on putting a position. My intent was on individually and what we're all doing. It's kind of like, again, for people who are for it and everything, and everybody makes their own choice, is to sort of go, hey, look, it's coming up. We're almost in October. Mail-in ballots, going to be going out, I believe, et cetera, and to use our voice. I say it unabashedly. Of course, I'm for this. I talk about it in front of town halls that I have, community groups that I have. I tell people that I joke that if you want to defund the police, then please vote no on this, right? Because the police budget's going to be hurt for it. The fire budget's going to be hurt for it. Our roads, et cetera. Is it something that's perfect? No. I wish we had more public school funding. I think it went down, please correct me if I'm wrong, from 25 to 5%. I really wish that was so. Our public schools are so critical. My son goes to public schools, and that's very important for me and for so many. But I'm certainly using my voice on this, and I hope that, again, everybody. I know Councilman Miranda, who we all love and respect, has his opinions, and I respect that 110%. But for those of us who are for it, I think that we should use our voice on social media and through every means necessary. We could do a vote here on City Council going, do we support this? Yeah, that's not going to do anything. What we have to do is when we go talk to groups, talk about how important this thing is, which is that this has been going on for 30 years. This is what it's given us. This is what it's going to give us in the future, and work with groups like ATU, work with groups like Local 754, the PBA, et cetera, to reach out to people that support the work that they do, because without this money, you know, we fund our police stations and our firefighters and everything through tax dollars. We don't fund them through lemonade stands. So that's something, that's why I support it. Is it perfect? No, but nothing in politics is. So, yeah, but again, that's why I did it, just to make sure that we're all out there working like hell for it. Thank you.
Councilman Moran.
I can only say, I'm not opposed to the owners of the sports facilities doing the best they can to get the revenue that they need for whatever reason. They're doing a fantastic job for the family. I have no quarrels with them. I have a quarrel with the way we work. We're afraid to say the truth. For instance, 597 for public facilities. Do you think the average person knows what a public facility? They don't think it's a park. Do you think anyone can go into one of these public facilities at any time and say, here I am, I want to walk in? The absolute answer is no. And then right under that, they put, other than 597, they put 545 million to be split among the sports stadiums. So for the first time, they mentioned sports stadiums here, but they will not put it that way on the ballot. It's getting the voters confused so they can vote the way some of us want it to go. Raymond James Stadium's annually will split that, and 52 million going for parks. That's in the county area. In the city area, they get 339 million for public safety in the city, 191 for vehicles and equipment, and 148 for facilities. However, they get 253 million for public facilities. Again, public facilities. There is no such thing in the city as a public facility. They're called stadiums. And the public and we politicians are afraid to put it the way it is. The public, it has to know the truth. And let me tell you another thing. When you look at this thing and you see what you're doing, a stadium is not anything but a public facility, absolutely not. Because you say it is, I say it's not. They don't tell the public the truth. We're afraid to say, this started in 1996 in February or March when they put it just for schools and education and the city the way it should be. And nobody gave a hoot and a holler, nobody raised a penny to pass it, and it failed. All of a sudden, they put the stadium in, they spent $484,000 in 96, and they win by 2.5%. 2.5%. If we're afraid to get our own money and put it in the streets that were paved a long time ago and spend all the money in them, we would have had what? Golden streets. We would have had anything you wanted. You would have had all the cars you needed. You would have had all the electrical you needed. You would have had all the hookups you needed. But no, we don't do that. Aside from that, you give away what? $2 million of the first monies earned by the Sports Authority goes to who? Somebody who doesn't have one penny invested and can never take a loss. For the first 7 years, from 1999 to 2006, they took in $10,269,000. The Sports Authority didn't take in one penny. For the total sums of the 30 years, they have taken in $63,580,247. And the Sports Authority took in 21 million, this is 63 million. So what I'm saying here, the people who earned the money, the Sports Authority, they have to give it 2/3 back to somebody who doesn't have one penny invested in it. It's comical in a way and really sickening in another way. And I'm not, in 2022, the stadium took in $195 million out of the stuff. I can go on and on. In fact, here's another thing of interest. The Sports Authority from then to now has taken in $261,946,000, well, the city took in $393 million. What has the Sports Authority done for the $261 million compared to the city's $393 million? Hasn't been answered, has it? Hillsborough County Schools took in $655 million, and the biggest was Hillsborough County, $1,200 million. And when you look at the projections for the 5, 10, and 10-year deal, here's what it's going to cost you. Architect fees, first 4 years, $53 million. The total is more than the total, 28 to 37, $202 million, and 28 to 48, $194 million. And here's the one that really bothers me. AV and technology, $138 million, and there's nothing, no backup material. You think you talk about transparency here? Where's it here? There's none. They're taking in $498 million. And it's just, the public is saddened. The public is not going to vote for this tax. It's because we don't present it the right way. We should take it all for ourselves. The public doesn't have a chance to go to half of these facilities because they don't have the money to get in. They have a contract for 30 years now, 1 penny increase in rent. And we have people living on the street that we got to subsidize for rent payments. An apartment find them, we have to do it, and we don't have the money. If we had this, we wouldn't have a problem. We won't even have homeless. But we have the problem because we create our own problems and pat our back in the back what we're doing for society. They're going to get the police cars. They're going to get everything they want. All we got to do is not pass this and pass it in 2028 and give it back to the citizens who put it in. Thank you.
Councilmember Hurtak.
Thank you. I completely agree with you that the contract is bad for us. Unfortunately, we're in the contract. We're going to have to pay them every year regardless until it's over, and then we can renegotiate. So, I mean, for me, this is important because of the other things it's doing, police and fire. I am not one that wants to fund a stadium, and so I'm very thankful that the Rays didn't, stayed in St. Pete. But this we can't not pay it. We're contractually obligated. So to me, this is not as important as, because we're already obligated. And there's a lot of stuff we're obligated to that I'm not thrilled about, but we are. Decisions that were made before I sat in this seat. So going forward, we have to support our police, our fire. There's no way that we can do that going forward without raising our millage or taxing ourselves again and trying again in 2028. I guess we could try in 2026 if we tried a completely different tax, but no, we can't. Okay, 2028 it is. So I've been enjoying you putting these up as we're going. This is great, and if these are types of things that you might be willing to share in an email or text messages, things. I guess we can just reshare on social media. But I do appreciate what you're doing going forward. The factual information is very helpful, but I would actually love some physical copies of this so that I can take it with me when I go places to show people, if you wouldn't mind.
Yeah.
Giving some color copies to all of us, maybe like 2 or 3 copies. I'll try to keep them original.
Like a one-pager sort of thing?
No, just like this. So
just
a couple.
these? Okay.
Yeah, just these. If I could just get photocopies of these, these are great, and that way I can kind of show people what they've paid for, what they're going to pay for. This is more tangible, and I appreciate the work that you're doing behind this.
Yes, just keeping it real for folks that are listening and people who are up here. Absentee ballots in Hillsborough County go out 2 weeks from today. They'll be mailed by the supervisor of elections in 14 days. This is the time parameter that we're looking at. I cannot even imagine what it's going to be like trying to do a budget for the city of Tampa without the CIT and without any additional revenue. I mean, it's all the points are valid, but again, and as Councilman Hurtak just reminded us, we've got contractual obligations that have to be paid. We can't go back there's no machine to take us back to renegotiate those contracts. That's done. They can extend those contract at their will. So we're going to have to come up with the money. I don't know where the money's. I mean, how many employees are you willing to lay off? I think who was it? Councilman Vieira said you want to defund the police. This is the way to do it. You want to defund. You want to not build fire stations. Hey, this is the way to do it. I mean, what do you want to sacrifice in the city of Tampa? Because we're talking a substantial sum of money, and that we fund just the normal daily business operations of the city of Tampa with this. I don't know if this city without raising taxes in another way, I don't think we can function as a city. We're already, as we highlighted just the other day, we're already the lowest millage rate. I mean, our millage rate is lower than everybody else. So, I mean, good luck with this.
Yep. All right. Yes, ma'am. Councilmember Henderson.
Councilman Miranda, I really appreciate your perspective, and I agree with you. That's all I want to say.
Thank you very much. Thank you very much, sir. Item number 7,
Just one more thing, just
yes, Councilmember Hurtak.
based on Mr. Clendenin. Also, it's a good time to check and make sure that your registration, your voter registration is up to date.
Yes.
So try to check every week before the election.
VoteHillsboro.gov.
All right, item number 73. Item 73 is a motion by Councilmember Vieira, and we
We
have,
said yes, but I'm good with the receive and file.
Is that the Italian club?
yes,
Yeah, so.
what's the GPR scan?
Yeah.
Yeah, I was going to receive and file, and I know Councilman Henderson, you had indicated you wanted to have staff here. I was going to make a motion at the end, and I'll do it at the end, just correspondence to the Italian club on cursory issues and everything. But yeah, no, I'm fine with receive and file.
Yeah,
All right,
so am I.
let's get a motion to receive and file 73. Motion from Councilmember Henderson, second Councilmember Vieira, all in favor? Aye. Any opposed? I think this is the last item. Item,
goodness.
item 74, and we have Miss Abby Feely in the audience. Or no, Mr. Cotton. Item 74, there is a PowerPoint. Do you have the PowerPoint?
I have a paper copy.
You have a paper copy? That's
Yeah.
great, too.
I'm old-fashioned or just old.
Oh, this is the parking leases.
No, paper's good. It's the traditional way.
Yes.
Go ahead,
Eric
sir.
Cotton, Development Coordination. This is a result of a council motion from a couple of weeks ago, which was to address the off-site parking under 27-283.6. The specific motion from council was asking that land development staff come before you to address the length of leases and such for when people use off-site parking. Andy Scaglione, who spoke last time he was here earlier. He arrived at 1:30. He left a little after around 4:15, so.
Yes.
But he said he would be watching this. So I just want to go over, so the current code language, what we're going to talk about, the current code language, current parking challenges that the city has, the lease terms and the language in the lease, and then staff recommendations. And we did draft up some quick amended language. If it's council's pleasure to move forward, we would include this in the July cycle, which I come back next week for the workshop for the July cycle. So, in summary, this is the current language in the code. For both residential and commercial uses, it allows someone to utilize off-site parking. The use being served by the off-site parking has to be a use that's allowed in the zoning district where the parking is being shared to. So if you're a medical office and you're zoned CG and you want to use off-site parking, the zoning district that you're utilizing the off-site parking has to be like CG, CI, or IG that also would allow a medical office use. It has to be within 1,000 feet on a safe pedestrian route, and the code goes into a little bit more language, and the long-term lease has to be approved by the city attorney's office. So the city is running out of land. I mean, I think we have 3 or 4% vacant land that has yet to be developed. So part of it is the cost of providing surface parking or structured parking. It is extremely expensive. The best use of the land often is not a parking lot. Parking lots just sit there, and they're used occasionally or often, depending on what the business is. And then you have the overparked uses. Our rate for retail is 4 per thousand. Some developments, when they come in, they park at 5 or 6 per thousand because their business model says we have to have that much parking. The other concern always comes up, if you don't have enough parking, where do the people park? Which then, so you can end up with overflow into neighborhoods. And then we also need to ensure that the off-site parking, that if you're going to go off-site and share parking, that off-site parking has enough parking for its use and the use that's going to be shared. So, for example, if I'm a retail establishment and I'm looking and I want to open up a business, but I only have 10 parking spaces and I need 15, and 2 doors down there's a parking lot that has a use that requires 10 parking spaces, but they have 20, they're overparked. I could maybe perhaps utilize that parking. So the discussion that was brought up last week was lease terms and language, which is the length of the lease. The code is silent. It just says a minimum, it just says a lease approved by the city attorney's office. Right now, through the city attorney's office, the lease has to be a minimum of 10 years. When I started working here, which was a while back. I believe it was 99 years. So almost putting an ownership interest in that person who was utilizing the lease. Nobody wants to tie up their property for 99 years for somebody else to park on it. That was amended, and it was to 5 years. Previous administration was allowed about 5 years. Now it's up to 10 years. One of the requirements of the code right now is that lease has to get recorded. So it shows up in the clerk of the circuit court as somebody does a search on the property through a title search, that lease will show up as being a recorded document. I may have to have Susan address the signability. The measurement distance of 1,000 feet, there has been discussion in the past of shortening that or moving it to 1320, which is a quarter mile. And then a termination clause, if the lease is terminated, what happens? There's usually language in the leases now to identify that the city gets identified. The question is, what do we do once we're identified of that information? Staff does have some recommendations. One, remove it, make it only for non-residential uses. So an apartment complex or a condominium can't get parking off-site for somewhere else. And so if you are building apartments that have 500 units and require, let's say, 600 parking spaces, they would have all 600 parking spaces on their site, whether it be on the surface or stacked or however that would be. A minimum of 10-year lease term, we could put that into the code, clarify how distance is measured, how the 1,000 feet is measured, require notice to the city, codify the requirement that city gets notified if a lease is canceled by either party. And this is the one to ensure that we know that that other site that's the person is borrowing parking from, where the shared parking is coming from, making sure that we have an as-built survey that shows how much parking is needed, what the parking layout is, making sure it all functions. Because one thing we don't want to run into is having people utilize a site that does not have functional parking. So this is not etched in stone. This is, I have a blow up of each of these individual things on a separate, on separate sheet, so it's more legible. So the first one is just showing that the proposed use, the use that needs to borrow the parking, is a principal permitted use on the site that the parking is going to. Going back to my example, if it's retail, your zone CG, you can't go park on an RM24 church lot because retail is not allowed in the RM24. The 1,000 feet measurement, which would be measured from the vehicular entrance of the place where the person is borrowing the parking to the pedestrian entrance of the property that you're utilizing the shared parking. And they would have to submit a plan to us showing, whoever the applicant is, showing the way the person is walking normal pedestrian route, where crosswalks are, if it's lit and not lit, and how it's properly marked. Again, this is going back to what I just said, utilizing an as-built survey, no more than 5 years old, so we actually know how that property actually is situated. And then the final language that would be in the code would be ensuring that the lease is a minimum of 10 years old, 10 years long, and that once it's recorded, before we would issue a letter, it would be recorded, but we would get a copy of that recorded document from the clerk of the circuit court. Does council have questions?
Anybody? Council members Clendenin, Hurtak.
This whole issue is perplexing because I think one of the things I've heard from the time that I've been on council is that we're overparked. And we provide parking waivers just about every time we approve something, we provide parking waivers. So I'm not quite certain where we are. I'd like to make a suggestion that we move this issue to the February 27th, 2025 workshop and workshop what parking looks like in the city of Tampa.
I'll second that.
There's a second. Okay, so we'll leave that. Councilmember Hurtak.
And honestly, I was gonna say almost the exact same thing. When I look at this, for me, but some of this is a part of the land development code rewrite. Mm-hmm. But to me, we're creating more of a problem because what we're doing by adding more restrictions is we're basically hamstringing people from developing. And that to me is a struggle because if we're taking out the residential possibilities, then if you want to have a 6-story building, you're going to have tower parking, and that's cost prohibitive. So we don't have land to continue to park people on the ground, we're gonna have to go high, but at the same time,
Can I say, let's not get into the merits of it, let's just workshop this, because I have a lot of thoughts on that too, and let's just
well,
defer
but-
this to the 27th.
but that was, yeah, so I can't, I don't really support these measures, was basically what I was going to say, but I will
I mean, I
support
agree-
if
I
he
agree
wants
with
to
you.
go forward
Yeah,
on.
I mean, I agree with you, but I think we just have that honest discussion on the 27th.
All right, Ms. Feely?
Thank you. Abby Feely, good afternoon. Couple things. One is we come to you next week with the July cycle. As I've mentioned a couple other times, we are not gonna process any other text amendments after the July cycle because we are now in the holistic code update. So I don't wanna put this in February and then start tracking it thinking it's gonna come in the January cycle, or there will not be another cycle. So just to walk back the issue for a moment, this relates to the Ybor City issue where there was a residential project. The residential project had a lease for off-site parking. That lease terminated 60 days after. I think there was a termination clause in the lease that talked about the ability to terminate 60 days after, or with 60 days notice or something. And what Mr. Scaglione brought forward to you that you made this motion based on was that there is a loophole in providing off-site parking with other entities. Because if you can demonstrate that you're using that for zoning compliance, but then you can go off and terminate it in 60 days or whatever that is, you're not really in zoning compliance anymore. But those things are falling out. So I think that's where the recommendations came from. We don't have to take any action. We could leave it as it is and let it come through the code update and see what the Clarion team might recommend in relationship to a process for allowing shared parking or off-site parking or these types of lease scenarios. But, and we can still workshop it. That's still an option as well. But I just want to set expectations in relationship to if we workshop it in February, where it's going to go. Because I've been very clear in my representation to the public and others that we are now in this other cycle, and I don't want to be working on things outside of what they're working on when they're trying to look at everything holistically and us be tracking in a different direction. So I just wanted to get that on the record. Clearly, it's the pleasure of council, but we will not have a January cycle.
Councilmember Campbell.
So, what I heard what you said is that this will really be incorporated into this longer-term solution that you're working on. And we've lived this long the way it is right now, so let's just not take any action and let's let the process flow out in the longer-term solution.
And the only other thing I'm just gonna say to respond to that is unless there is something that Ms. Johnson-Velez and Mr. Cotton feel are grossly wrong in the code right now and would suggest with that minor changes or without changing content to Councilwoman Hurtak's point about taking the resi out or leaving the resi in or how we wanted to do that. But if there's something else that y'all need addressed now, I would say, please say that so we can do that. And if not, if it's the pleasure of council, we can make sure when we're working with the team that we have that discussion.
Now, would it be beneficial, because I think Councilwoman Hurtak and I are simpatical on this issue. Would it be beneficial with your longer-term strategy and work to have the information of the sentiment of council in a workshop in February?
That couldn't hurt.
Right. So,
I'm never gonna
okay.
say no to that opportunity to discuss that. I just want the expectation to know that it would travel in the code.
So I would say let's go ahead and workshop this on the February 27th.
Councilmember Hurtak.
I just had one question, and it's that you brought up that when is the projected time to get those changes from Clarion? Like, what are we looking at? Are we looking at 2026?
Yes.
January?
I believe that the first public hearing, and please don't quote me on this, if I
No, I'm
need to
just trying
correct
to find a
myself, I
ballpark.
will. But I believe the intended first hearing of the full draft would be spring of '26.
Okay, so that's what I thought. But if we do have issues or think things, we can come to you and kind of find out where they are in the process when we do have issues. So that is a way that we can deal with some of the concerns we may have between now and then.
Yes, the
Okay.
next forthcoming installment is the assessment, and after the assessment, the draft code will come in 3 installments. So there'll be 3 pieces then that we'll be working on before it's all packaged up into one code.
Okay, great, and we'll be able to take a look at those 3 sections, and so that's when, okay, perfect. I just wanted to get a little more clarification, because when you say we can't do code changes for a second, you're like, but knowing where the stops are is helpful, so thank you.
You've got to kind of trust the process.
Exactly.
Carlson.
Yeah, I would, this has been an issue for a long time. Besides Ybor, it's been an issue on Howard Avenue for a long, long time too. I mean, people make fun of it because there seem to be multiple leases on the same spot of land. I agree with everything you said a minute ago. I wish that we could put this in this cycle, and then if somebody wants to modify it in the bigger process, go ahead. But just because it's been out there a long time doesn't mean that we shouldn't try to fix it now.
All right, we have a motion and a second. This is for the workshop in February.
February 27th, is it?
Yes. All in favor? Aye. Any opposed? Thank you very much.
Thank you.
It's time for new business. All right, Councilman Miranda, do you have new business?
Oh, yeah, I have so many of them, I can't take it anymore. You'll have some new business when you want to start spending the money.
All right.
We're gonna give you the budget.
Councilmember Vieira.
Yes, sir. I got a couple, if I may. I had mentioned the Italian Club. I motion, and I can do this letter, Council, and obviously it's not going to be anything controversial, I'd say. If you guys want to take a look at it before it goes out, that's fine. But a motion for a Tampa City Council letter to be sent to the Italian Club showing our disappointment at their failure to appear before council as previously requested, and encouraging to be transparent about their findings as it relates to the allegations as to the cemetery for transparency.
We have a motion from Councilmember Vieira, second from Councilmember Henderson. All in favor?
Aye.
Any opposed? Yes, sir. Anything else?
Oh, yes, I'm sorry. So I actually got a few, and this is one that I think City Council's gonna get some good use from. Daryl Butler is our Racial Reconciliation Committee facilitator, and I wanted him, I don't think, do any of y'all know this gentleman?
No.
Any of y'all? So that'd be great. So I would like for him to have us join us virtually at the regular session on October 3rd of 2024 for a short 5 or 10 minute briefing. We can limit it to 10 minutes.
Are we paying for it?
No. Yeah, no, I don't believe so. We're under budget. And I'll confirm, but that's my understanding regarding the upcoming committee meetings and plannings. So that's all. We can either do it under ceremonials or after lunchtime, whatever it's council. I just think it'd be good for us to hear from him. I think it would provide some good substance for us, because I've been dealing with him a lot, but I think we all should.
If I can,
Yes,
Counsel.
sir, Mr. Shelby. We
I
have
believe,
two commendations and a presentation from the SBA.
Staff report if need be.
well, but here's the thing, Councilman, and forgive me if I'm out of line.
Not at all.
But this gentleman is going to be coming in remotely, is my understanding, and he's going to be coming in from Orlando. But he's not going to be driving in, he's going to be appearing remotely. So I would respectfully request council to be able to accommodate him, even if it means giving him a time under, and if you have to waive the rules, it would be my recommendation to do that.
Can we
But
do
some
like a
sort of-
time certain,
some
1:30
sort
or
of
something?
time certain would be
No?
in order. What?
Oh. Do
have
you
a-
want to
a
do a
one-
time certain later after that, like a 3 o'clock?
But then the thing is, we won't know when he's going to be on standby for how long and what time.
You want to do a time certain of 3 o'clock? If we have 2 review hearings that start at 1:30, let's say they take up that whole time, or we can do a hard pause at 3 if he's just going to do a quick presentation. It's, what?
Why not just why not just do a time certain in the morning?
And if it requires waiving of the rules, that would be a supermajority.
Yeah.
But council, frankly, that would be my recommendation in order to accommodate him. And it would also, the other thing it would do to make it in the morning, an advantage to that would be public comment would be there, and the public tunes in to be able to hear him and to see what exactly this committee is.
That's a win-win, win-win.
Win-win.
All
Yeah,
right.
and again, council, I do that, and Mr. Shelby, trust me, you're not out of line. You put in a lot of time on this, and I appreciate you. So yeah, I just think it'd be useful.
You want to waive the rules and do it at the beginning?
I
Yeah,
might
talk
motion to
with the
waive the
time
rules
certain.
to give a time certain
And
of
if it's 10 minutes?
10 minutes.
Up to
at-
10 for everybody. That includes him, all of us.
Well, the council may have some questions, but you should remain mindful that you may be able to reach him individually offline. I don't know how that
How how about 10 minutes immediately following the accommodations?
Okay, that's fine. We have to, yes, Councilman Carlson.
Yeah, is it possible to pick a different day, like November 7th, instead of waiving the rules on?
The council, the committee, the Racial Reconciliation Committee was supposed to begin in September, but because of the logistics, it's now going to begin in October. This would be very timely for council and the
Okay.
public to hear about.
So we have a
Can we
motion.
move accommodation then, instead of waiving the rules?
What are the accommodations?
Oh, you have a presentation from
ATU
the
and
Small
police
Business
off.
Administration. I don't know whose motion that was.
I'll second waiving the rules.
Yeah, I'm fine. If I may, Mr. Chair, I think this is important for us to hear from him and to start
Developing a collective relationship with him. I think it's pivotal. I appreciate the reluctance on waiving the rules, but I think it's justified.
We have a
And
vote.
there was a question about the SBA. That was because the Hurricane Debbie and that time frame expires, and that's why they're coming out.
Yeah, so we have a motion to wa-
Yes.
You'll have the police, you'll have the police and
We'll
ATU.
do police,
here.
ATU, and then his presentation.
What's the motion?
We have a
That
motion
was
to
mine.
waive the rules by Councilmember Clendenin to add this under ceremonial. We have a second. All in,
After ATU.
Well, make that a second motion, please, just a motion to waive the rules.
we have a motion to waive the rules. All in
Second.
second, all in favor?
Aye.
Any opposed? The
Okay.
rules have been waived, but by unanimous consent. Yes.
And it's gonna be after the ATU presentation.
The motion is for this gentleman to present up to 10 minutes after the ATU presentation. Do we have a second?
Second.
Second from Councilman
Or-
Vieira.
I don't know if yeah, whatever.
All in favor?
Aye.
Aye. Any opposed? Yes? He was the
I
second.
know, I'm sorry.
I'll second it.
Yes?
And my only request to Mr. Vieira
Yes,
is that if you can give him some parameters, like,
Yes,
so,
yes, ma'am.
so
And
that he's
my-
not just talking, like, give him a outline of what we want to hear.
We know how you lawyers are.
I know, right?
All right.
So we will, and I know, and my wonderful aide is listening, and we'll do that.
All right, all in favor? Aye. Any opposed? Congratulations. Anything else, sir?
Congrats. And then just last, if I may, the Junior League of Tampa for Diaper Need Awareness Week, they requested a commendation, and I wish to give it to them. I'll do it off-site for the Junior League of Tampa.
We have a motion. Do we have a second? Second from Councilman Clendenin. All in favor? Aye. Any opposed?
Council. That's it. Thank you.
Councilmember Henderson.
Yes, sir. I have three things. First, I would like to make a motion. Adri Colini.
Yeah, Colina.
Colina, yes. I think, I want to move that she come before council and to give us an update on Hannah City Center in terms of facility use and future plans, just to get an update on that space and what's going on. I've heard some public comments about it, and I know that there are future plans to utilize space, so just to be very transparent about, the very
When do you-
expensive
when
Hannah
would you
Center.
like her to come?
You know what?
Do you want to get with her and then come back and give us an update next week?
No,
Okay.
let's pick a date. What's available? Thank you, Celine.
October 17th under
Yes,
staff report?
and Charlie seconded.
All right, we have
Is
a
that,
motion.
is that in person? That's not written. It's-
I want in person, I want transparency, I want the public to hear it.
Okay, we have a motion from Councilmember Henderson. This is for October 17th under staff
Mm-hmm.
report. Second, Councilmember Miranda. All in favor? Aye. Any opposed?
If I can, Mr. Chairman, I'm sorry to interrupt, just a reminder for council, October 17th is now at your limit.
It's with that motion?
With that motion.
Oh, okay.
last one.
All right.
Okay, thank you, Celine. And Ms. Attorney Shelby. Okay, and the other two are really just announcements. First, our workshop next week, Julian B. Lane, I'm going to be presenting quite a few suggestions. And I just want to make sure, could I give those to council in advance just for efficiency in a memo? Because I noticed,
Yes.
just for efficiency, but also if you have, some recommendations as well, feel
Then
free
you
to be.
can't- then you
That
can't.
sheet, they can't share, but feel free to at least, bring them before council on that day.
Yes.
Okay, thank you. And then the other one, Darlene, put it down. I just want to thank the Community Engagement Office. Now adjust it so it can fit on the screen.
Zoom out a little bit with the wheel, yeah.
There you go, Darlene.
Other way.
Other way. This is National HBCU Week. Make it a little bigger, Darlene. Thank you. Yeah.
Oh, all right, we
Yeah.
got it.
It's National HBCU Week, which HBCU stands for Historically Black Colleges and Universities as classified by the federal government, of primarily historically black institutions built and in existence before the 1960s. And so because of that classification, last year we had an event here at in the Sister City Room where we celebrated that with staff, and people came by and, you know, celebrated people who graduated from those institutions and other folks as well. So this year, I really wanted to activate the Hannah Center because it has kind of like a quadrangle yard space. And so I've invited the community as well as, you know, HBCU graduates and just anyone who wants to come. We're celebrating HBCU Week at the Hannah Center. And I just want to thank community engagement. David Herrera, he's a digital, his title is Digital Content Creator. He utilized a photograph, a picture, an artwork painted by Michelle Turkin, a local artist, and it really is a replica of just my graduation experience from Florida A&M University. But he incorporated that into the flyer along with the city colors, and I just want to thank community engagement, Vanessa Nettingham and Frank and Sonia and everybody else who worked down there, Janelle McGregor, their director, for helping me put this together. And hopefully you all can stop by, you know, and food trucks, music, vendors, just for a couple of hours. And hopefully this will be something that will turn into an annual event.
I am going to probably be there around 4 o'clock.
And you can wear a PWI t-shirt if you want to, because I know you're a bull, but you can come and cheer for us.
I'm going for the good vibes.
The good vibes. Yeah, and one of the things that's definitely going to take place, rest his soul, Frankie Beverly, wonderful musician, Frankie Beverly in Mays. He passed away last week, and his music is very big in HBCU culture, so you'll hear a lot of his music being played that day. So it's kind of old school, and I know for a fact that a lot of older historically black college graduates are coming, and which is really great because, you know, I don't want it to be, you know, a young people thing. I really want to activate our senior citizens, you know, to come out and hang out and have fun. So thank you.
Thank you very much. Councilmember Clendenin.
Thanks, Sterling.
I think we've already acknowledged that I require liquor to go anywhere, so is there?
You know what? I'm not going to address that.
I just want to thank everybody, because next week at the workshop, keeping it light, because we have kicked the issue on planned developments, PDs, down this. Every time we put this on the schedule, we've loaded the schedule up, and, you know, we keep deferring that conversation. So I'm looking forward to having that. This is one of those conversations that I've really wanted to have since I first joined council. I'm looking forward to that discussion. So hopefully you guys will come prepared to talk about that next week. And thank you for keeping the workshop light so that we can have the time to talk about it.
Thank you so much. Yes, Councilmember Hurtak.
Thank you. And sometimes I wish you would start on this side, because now people took my dates. So,
I do. Let's flip it around.
yeah.
You want it October 16th?
That's okay.
It's just like the prom all over
Yep.
again. We're taking my dates.
So I moved to have staff present a written report on the number of leases we have with the GTE building at 711 East Henderson Avenue, the number of employees that are housed at the GTE building, permanent and personnel during EOC operations, the amount we pay for each lease, and the beginning and end date of each lease to include current and former leases. I would like this to have a written report on the October 17th, 2024 agenda. And the reason I want this is because during my prep meeting, I found out that we are now housing the water folks there. So we have 4 leases with that one building. So I want to find out, this kind of goes with yours, but this is going to be a written report on the same date. So it should help that conversation go forward.
We have a motion. Do we have a second? Second, Councilmember Henderson, all in favor?
Aye.
Any opposed? Yes, ma'am. What else?
Last year, after the budget cycle, we asked to have the cover sheet amended somewhat, and last year I asked for both the account numbers that funds are transferred to and from, and I asked for the names. The names never happened. So I am going to move again I move to have agenda item cover sheets and resolutions to include the following information: the name and account number that the funds were transferred to, and the name and account number that the funds were transferred from. To begin with October 17th, 2024, under the projected cost portion of the cover sheet.
We have a motion and we have a second. All in favor? Aye. Any opposed? And then?
I have communicated with, this goes back to item number 36 from this morning. I've communicated with Ms. Kopesky and Director Mulkey regarding Parks and Rec lighting installation projects. People are very interested on which places are getting the lights. So through FY 2026, we have a $6.3 million budget, which is a substantial investment for this department. So I moved to have Tony Mulkey provide a quarterly written report starting on January 1, 2025, to include the locations with estimated start and end dates and budget projections.
We have a motion from Councilmember Hurtak, second Councilmember Henderson. All in favor?
Question, when does it start?
It starts in January because he has to get it going.
Is that enough time for him to get going?
This is specifically from him. We always track dates. So that's when they're really far in advance. That's why.
Okay.
That's what he said would be a good one.
I just want to make sure you guys
Yeah.
have time to get going.
And then today, as part of a written report, we got the quarterly updated stormwater.
Yes.
However, in the quarterly updated stormwater submitted as a written staff report today, the South Howard Flood Relief Project timeline states that the project is on hold. People were not, a neighborhood association reached out to me to request an update, so I reached out to Mr. Bide, and he says that he can give us a brief update on October 17th. However, there are currently now 7 in-person staff reports on October 17th, but one of them is the Mobility Department to provide a 5-minute quarterly update on road repairs. I would like to add a brief update on the South Howard Flood Relief Project to this in-person staff report.
We have a motion and a second.
And the only reason is because people are very concerned to hear that this is on pause.
Because people are so concerned, I think there's going to be a lot of attention to this. November 7th is wide open.
Okay, then I will move it to
Because
November 7th.
I think there's going to be a lot of interest in this.
Okay.
Is that fine with the seconder?
Yeah.
Motion and a second.
Can I
All in
just-
favor? Wait, yes?
Yeah, I had heard that there was a presentation coming up anyway on this, but I'm happy to support this. The other thing, though, is that there are folks that don't like the specific route. When you do engineering, you should never present one route, and there are people that object to the particular route that was proposed. And what we need to do is ask the administration to present a design-only or design and public input project, not a design-build, because design-build implies that they're going to move forward with either one route or a limited number of routes. So I just wanted to put that out in the ether in anticipation of this discussion. There are people that want us to fix this right away, and there are people that are concerned about the route. We need to make sure that we don't inadvertently push this in the wrong direction without input onto the routes.
Refresh people's memory, we took a vote to say we didn't support that Bristol route.
Yeah, just the
I
Bristol.
was just informed by Ms. Scharf, and I have it in front of me, there is a written staff report on October 17th, staff to provide a written report on using Bristol Avenue for the vaults and to bypass the neighborhood, which, by the way, the motion does not state which neighborhood, so I don't know.
But that's a written report, not a.
Right. As they would work to resolve the flooding issue using commercial corridors, and that council will not vote or fund a plan that places said vaults on
Okay.
Bristol Avenue. That was your motion?
So what I will do is, if you don't mind, I will take that written report and add it. Would you mind if the written report is added to the verbal report from Mr. Bide on November 9th? So we're all talking about it at the same time.
Good plan.
Okay.
So that's the one. That's the one that I was thinking, but I couldn't find it real fast. But yeah, it's right there.
Okay.
Is
So
that okay with the seconder? We have a motion and a second.
What is it again, please?
The motion is for Mr. Bide to, I have this written down, so I'll hand it to you, Suling. But the Mr. Bide provide us an update on the South Howard Flood Relief Project and an interperson staff report on November 7th, and to fold in Councilman Carlson's October 17th written staff report on the same item.
And will this be part of the quarterly update, or will this be
No,
the
the quarterly update is on the 17th. It's not on the 7th.
Oh, this is on November?
Yes, November 7th.
November 7th.
We have a
Thank you.
motion and a second. All in favor?
Aye.
And she has a copy of the motion for the question.
Yes, she will, yeah. And then my final one, today's Today's marathon alcohol beverage session reminded me that on January 25th, 2024, we had an AB suspension hearing for Grand Cathedral Cigars at 2101 North Florida Avenue. And at that time, it came to light that work had been done without permits and that the business was operating without a certificate of occupancy. I moved to have staff provide an in-person update on the Grand Cathedral and the status of their violations on October 3rd, 2024.
We have a motion and a second. All in favor?
Aye.
Any opposed? All right, anything else?
Nope.
Councilmember Carlson.
That's so good, because I've been thinking about it.
That's what made me think about it, or today's minute.
I have 4 proposals, but one other thing. Next week, there's also a discussion about parking for construction projects. You all heard in public comment this morning that people that live adjacent to the Ritz-Carlton project are upset because they claim that staff approved a parking layout for construction that takes up their space. And this has been happening all over the city. Folks know that construction is coming, but for example, Oxford Exchange a few years ago, when the building was built across the street, nobody expected they would shut down 3 roads and something like 50, 60 parking spaces. And so there's a discussion there to talk about how could city council better regulate or get involved with construction parking. So please think about that. And don't forget on the South Howard project, it might need to be renamed because there's opposition to it going on Howard, but at the very least, we need to come up with a design and public input process instead of just pushing one thing. I sent 2 of these out already to you all, so you've seen them. But there was a public meeting on Tuesday night while we were in our budget hearing and on Harbor Island to discuss a traffic light at Greco Plaza on Franklin Street that the Harbor Island people don't want. And so I would like to make a motion to ask mobility staff to appear on October 3rd with documentation including traffic warrants supporting the decision to put a stoplight on Franklin and Water Street and the proposed traffic light at Dick Greco Plaza. Additionally, I ask legal staff to appear with a list of actions Tampa City Council can take to prevent the installation of these stoplights.
We have a motion from Councilmember Carlson. Do we have a second? Second from Councilman Vieira, Councilmember Henderson.
Yes, Councilman Carson, I just want to ask you a question. When you say that they don't want a traffic light, I need you to clarify that. Just a group of people, or how many people, is the entire community that's saying they don't want this traffic light?
I don't know that they have any way. I don't know that they have any way to poll the community, but I can tell you that it's a large number of folks.
Okay.
And I've also, we'll talk about the merits of it on that day. But the point is to bring the staff back so that we can have a public conversation.
Okay.
We were not able to participate on Tuesday night, so this way we'll be able to participate. And the community can come. Those who are in favor of it can show up.
Okay, I just want to clarify when you say all, they don't like it, I want to make sure
Mr. Shelby?
who we talking about.
We need a vote.
Yeah, we got to vote.
Second, all in favor?
I can support it, aye.
Yes.
And then number 2,
This number 3.
this, the first one was just a comment. The number 2 is this issue of cemeteries keeps coming up. And, we've had private owners of cemeteries. Some of them have a lot of money, some of them don't. Some of them are for-profit, some are nonprofit. Some of them are government agencies. I don't know if some of you who weren't here may not remember, but under the old Fort Brooke over here, there were cemeteries found under the expressway. There's some found in West Tampa. And so this is not an issue just about one organization. I think ultimately the city should end up owning either the cemeteries or an easement to the cemeteries so nobody can build on top of them. But what's happened in the past is some property owners have, because they have the money, can just give them up and not do anything with them, but not everybody can afford to do that. And so I would like to make a motion to ask city staff to help council with a February 27th workshop discussion about the possibility of creating a city fund to assist property owners with an analysis to determine if a property contains lost graves and to buy the property and or an easement to protect the graves. So that it would help pay for what happens if you're an independent property owner and, we've had synagogue come before us, right? So so whatever the cost is of doing ground penetrating radar, they have to pay for it. But then if they pay for it, if the public doesn't agree with the response to it, then they have to do it again potentially. If the city pays for it and offers to run it, then at least that's alleviating that objection that somebody might have, and it might help us to better get control of some of these properties.
We have a motion and a second. All in favor?
Aye.
You know, it was mentioned earlier that we don't care, you know, but I mean, I think we go above and beyond when it comes to, Councilman Vieira made a motion, you just made this motion. I think we really.
Talk about it now?
Huh?
Are we gonna talk about it now?
No, I got more to talk about. I'm not on my thing, no, I think it shows that we really do care.
So
Go ahead, sir.
two more. After the meeting at lunch, we had like 7 or 8 consultants here for the waste to energy plan. And you all know, a year or so ago, I asked questions about what's the 20-year plan, what's the 30-year plan, all that. And we didn't get answers, or we didn't get complete answers. In 5 minutes, I talked to them, and they have all the answers. They have great answers. Like the question I asked this morning, did we do an analysis to see what it would have cost for the private sector to run this instead of us doing it? And they said yes. And some of the numbers they talked about publicly, but just in 5 minutes of talking to them, they have the numbers, they did the analysis, and based on the current numbers that they showed this morning, this project is beneficial to the public that that the city took it over. This is a positive case study, and if you compare it, I asked the question to them, if you compare it to the cost today, if we had to hire one of those companies to take it over today, what would that cost be? Because the costs have gone way, way up. What it will show, based on what they told me this morning, is that the city made a great decision. I was not involved in the decision. I think I helped vote for it. But it turns out that in hindsight, the city made a great decision to do it. I think we need to show transparency into those numbers because it will help the public gain confidence that the city did the right thing. And so I would like to make a motion as city staff and the consultants to present on February 20th as to a comparison of the original projected cost of the waste-to-energy plant to the private sector's offer at the time and compare those to the actual costs as of this date, at that date, and the current private sector costs.
We have a motion and a second. All in favor?
Aye.
Is there a date? February 20th.
I said February 20th.
February 22nd.
Wait.
Yeah, can I ask a question before we finalize, because I haven't voted on this? To what end, though? I mean, because it sounds like it's an awful lot of staff work and a lot of money to
I don't remember if it happened when you were here, but in the beginning, I asked a lot of questions that were like basic questions you'd ask about a project. And the public was very concerned because we had about 4 different sessions where we talked about it. And there were a lot of questions that were not answered. And so there are members of the public that have concerns about the transparency at that time. In talking to staff and the consultants this morning, all that data exists, but it's never been presented to us or to the public. And since it's a very positive success story, I would suggest that we have it presented.
Okay, thank you.
We have a motion and a second. All in favor?
Aye.
Any opposed? Anything else?
Yeah, the last one is, I sent this one out too. I don't agree with it having a quote-unquote CRA in the Sulphur Springs area, but I did talk to the CFO about the possibility and others about creating a budget focus area or a virtual CRA. And so what that would be is we would check the costs, the ad valorem taxes that are collected within a certain geographic area now, and we would track it every year just as a separate budget item that we would track. And then we would look at the cost of what we're spending in Sulphur Springs right now, and then track that every year thereafter. But unlike a CRA, we're not required to do anything, but we can look at that as information to decide if we want to spend more or less. So if some big developer moves in and makes a big investment and the ad valorem taxes go up, then we could decide to spend more. I would like to make a motion to ask the CFO to research the possibility of creating a virtual CRA or budget focus area for Sulphur Springs and to report back to City Council on December 5th. The idea would be to draw a boundary around Sulphur Springs as if it was a CRA district, and to A, count the current and future ad valorem taxes collected in that area, and B, to count the expenses the city is spending in that area. This would be an annual budgeting tool to enable City Council and the administration to determine if and how more investment should be made in Sulphur Springs. Unlike a real CRA, the budget would not be limited to any new ad valorem taxes or the lack of them. In addition, the city would not be constrained by CRA rules or requirements. This is only asking the CFO to talk about the possibility of it, and he and I have already discussed it. It is possible. We're not asking him to do a report yet.
Do we have a second? Do we have a second so I can go to discussion?
Second.
We have a second from Councilmember Hurtak. It's gonna be, Henderson first, Hurtak, she had her mic way before, Hurtak and, Clendenin, and then Vieira.
First, I really appreciate you putting this motion in writing to us because it gave me an opportunity to, do a little digging. And on September 5th, we approved $250,000 for the Neighborhood Action Plan for Sulphur Springs. And so let that process play itself out. We've already approved that. There's money allocated for it. And so if we just allow that function to work and to see what happens, then maybe, we can look at a recommendation for the CFO to get involved with, some additional research. I just think that we have already invested in a plan that we just approved what's today? The 8th. 2 weeks ago. Yeah, it's like 2 weeks ago. So I think that is a better opportunity for us because we've already directed staff. And I think there's a consultant involved too, as well. So that I don't want to support it right now because we have the Neighborhood Action Plan. Thank you.
Hurtak, Clendenin, Vieira.
And I had the same sentiment. We had just approved this, but I think that you could take your motion and combine it as part of the action plan to work with the consultants. Because I think the idea of, seeing what that tax revenue would be is a good idea, but they already have, I have to assume they already have an outline of the area. So I would recommend that you work with them and then come back and have yours be in tandem with it. It would be a separate motion, obviously, because that's not part of their scope of work, but to be in that same, vein. I think it's a good idea, but I also want to make sure that it doesn't compete with the action plan that's coming.
Clendenin, Vieira.
So just discussing the merit of having the discussion, is one thing. I think that having the discussion, of course, it may be a little bit premature as the first two council persons just discussed. I also, on the merits of the issue, clearly Sulphur Springs needs a lot of investment, probably more investment than we can afford. And we already know our budget is so constrained, and God help us as if the CIT doesn't pass. But, if we wall off, who is left to pay the bills as we create more of these, walled off districts? There's not going to be any money flowing to pay. You talk about the rest of the city is going to be woefully lacking any money to pay. We're not going to be able to pay police. We're not going to be able to pay fire. We're not going to pay anybody. But we are not restricted to invest. If the money is available right now, it's because it's already an economically depressed area. They probably don't create the ad valorem to be able to have significant investment there. And if we're able to free up money somewhere else to be able to do that, I don't even know if we should be restricted to whatever is collected in that area. That it may be an area that needs more affirmative action to be able to get to where it needs to be. I think our future land use changes up there are going to help significantly as we can, if we could encourage more affordable housing, construction into that area and to bring people up there, increase the population levels of some of because we have a lot of desert areas of undeveloped or underdeveloped areas. And if we could bring people there, the economic catalyst would kind of resolve some of the issues itself. So I think it's kind of premature. I'm going to go with the two council persons, kind of their same sentiment.
Vieira, me.
Thank you very much, Mr. Chair. So I tend to agree with the comments that have been made. I was thinking about this. I wrote down some notes when the motion time started. Obviously, I deferred a lot to Councilwoman Henderson, as she's the district person over there in Sulphur Springs, and we're not in our capacity here at CRA. This to me seems to be something that could be better worked out through a council request to maybe have it in April or so, April, May, that the administration report on what they're proposing to spend in Sulphur Springs each year. I had motioned for that in the budget this year, and we can look at that. It would be at the very least duplicative right now of the study that Councilman Henderson and others have talked about. Another big challenge with me is that I'll say it. Look, the CRA got 2 votes, right? I support it. I support talking about it, but the CRA has clearly spoken. This body has clearly spoken. I accept that. It's not time to open up the interlocal agreement and have that conversation, which is gonna, with a lack of support, waste staff's time. And there's a lot of concerns there. I obviously accept that 100%. My challenge is this seems to be more responsive to wanting to undermine a future movement for Sulphur Springs CRA, which I do believe is inevitable. And I do think that if Councilman Carlson were to make a motion asking to have the administration report on what they're going to be budgeting in Sulphur Springs a couple of months before the budget so that we can influence that, I'd be truly in support of that. Again, the CRA has spoken. I know there was also a request for an expansion of the CRA over in Ybor City, I think for the art space as well as for Sulphur Springs. So I respect that, even though, again, I support that. So this is something that we can look at, including different measures after the study is done and everything. But again, if a motion were to be made, Councilman Carlson, on taking a look at requests that have been made by the administration in the budget, we can do that. I'd support that.
Miranda.
I'd like to make one motion. I think I'll answer a lot of the questions you have in mind. I'd like to ask the administration to give us a complete expenditure of what they've done and the expenditure of District 4, 5, 6, and 7, which comprises the whole city, and you'll have all those answers. They'll give it to you, the computer will give it to you. I say, within 2 weeks, you'll have, or 1 week, you'll have all that answer.
Will that include CRA fund?
No, not the CRA fund. I'm at city funds that are expanded by the city in District 4, 5, 6, and 7. If you can take the CRA fund, that's another animal.
And isn't a little bit of Sulphur Springs yours as well?
Part of it. But they say that Sulphur Springs, last time I looked at the district, it ran straight down Florida Avenue. But it might have changed, I don't know.
Councilmember Carlson, you have a motion.
Yeah, if I could just respond real fast, this is not creating a CRA, it's not creating an action plan. It's simply asking the staff to talk about the possibility of annually giving us two numbers, how much ad valorem tax is generated in Sulphur Springs, and number two, how much is being spent. And it seems to me that those two numbers would be tools that could be used in any of the things that you all talked about. And so if I still have a second, my motion will hold, and I just want to know I want to have a discussion about whether we should ask for these two numbers, and so we could have a longer discussion another time.
I thought I had made a motion, but evidently I didn't.
No, his motion was first.
Oh, okay, I'm
If
sorry.
you want to make that, I can take that motion out. We have a motion from Councilmember Carlson, which I will.
Just to have a discussion about whether we should ask the staff for these two numbers on an annual basis. When? December 5th.
December 5th. We have a motion from Councilmember Carlson, second Councilmember Hurtak. All in favor? Aye. Any opposed?
Nay.
I'll take a roll call.
Do a roll call.
Carlson,
Yes.
Hurtak,
Yes.
Clendenin,
Never hurts to have a discussion, yes.
Henderson,
No, never that.
Vieira. No. Miranda.
No.
And Maniscalco.
Yes.
Motion carried with Henderson, Vieira, and Miranda voting no.
Thank you very much, Councilmember Miranda.
I'd like to make a motion so we can get all the expenditures in District 4, 5, 6, and 7, have the administration give it to us in 2 weeks on an item there. Put on the agenda.
Written
Pardon me?
report.
Yeah, written report.
All right, we have a motion and a second.
Question. I think without including, maybe on a separate page, but without having the CRA numbers, it really is kind of meaningless, because you need to see what the total taxpayer
Well, let's
investment.
have two of it. Let's have one
Yeah,
with the
you can-
CRA numbers, one without the
Concur.
CRA.
Can we
Exactly.
do it for November 7th?
November 7th sounds fine.
Would you accept that amendment to have
Yes,
the
sir.
two?
Yes,
Thank
sir.
you.
What was the amendment?
To have a separate for the CRAs.
Okay. Yeah, we can ask.
So we know how much taxpayer money being invested in each district.
This is for November 2nd, under staff
Seventh?
reports written.
Yes.
We have a motion and a second. All in favor?
Aye.
Aye.
The 7th, is that?
7. Yes, I asked him if because it was a hit. Anything else?
If I may.
All day long I've waited. No, please. I'm not gonna
Appreciate
sit
that.
tonight.
Since, and this won't be any discussion, I mentioned it since, again, I would have supported this from Councilman Carlson and everybody else, I'll make it, which is I would ask that in May 1st of 2025, the administration come to Tampa City Council on what it intends to put in that year's fiscal budget for the Sulphur Springs area, just so that we have a good working roadmap of what
Yeah.
we're talking about, so we can really concentrate on that area to do what we can. Again, this has nothing to do with a CRA or undermining or supporting a CRA. Council has spoken on that, just helping the area, that's all I care about.
We have a motion and a second. Yes? No? All in favor? Aye. Any opposed? All right, thank you very much. I have a couple of items. So
Wait. I recognize Chairman Guido Maniscalco.
Hey, follow your own rules, bud.
Lisa, 9 hours I waited for this, 9 hours. So anyways, I met with Adri Colina and Gene Duncan the other day, and they showed me some renderings and an idea about moving city council chambers from the 3rd floor to the 1st floor. And the 1st floor being this back corner here, basically facing what the mayor's office is, you know, where the fountains are at. The cost that they gave me was, they had $1.2 million now, but they needed another $1 million. And, you know, I have several concerns. First, council offices and chambers have always been on the 3rd floor. Second, the amount of money that it costs, I think, is insane. Third, I got here real early today and I walked around these chambers and I looked at what we could do remaining in these chambers. I think we should do replacing the seats, replacing the carpet. There's cracked paint and plaster all throughout. You can see where the drywall's been repaired. I think we can spruce up this area here. The clerk's offices were recently done. They came out beautiful. But other than that, I think we should look at, if we're gonna spend money, renovate the 3rd floor, but taking us down below, I have several concerns, security concerns, monetary concerns, and whatnot. I'm not here for a deep discussion. What my recommendation would be is that each one of us reach out to Ms. Colina so she can show you all the renderings. But it's not really a motion, it's just a suggestion. So Carlson was first.
Okay.
This is the first I've heard about.
Hey, who's chair here?
All right, you do the
I recognize Councilman Carlson.
This is the first I've heard of anybody, I don't know if everybody else knew about it.
No, this
but
just came up last week.
I didn't know
wanted
anything
to bring it
about this idea, but we do know that the area over here is where the public experiences coming before us. And so anything we can do to improve the spaces that the public experiences, I think is a good idea.
I 100% agree.
I recognize Councilwoman Hertz.
Sorry, I was looking at him. I apologize.
I have no gavel.
Safety is #1 concern. I actually talked to the folks downstairs and they agree. And I won't go into detail because I've been asked not to go into detail because of our security measures, but I am very uncomfortable with being on the 1st floor and having a window there. I think that's, for me, is a wildly unsafe. But there's, I mean, for less than $1.2 million, I think we could even maybe, you know, bring Mr. Shelby in a little bit, or, I mean, we could add some permanent things for staff. I mean, there's things we could do to spruce this place up.
Yeah.
But I agree with you. I did not know the history that we've always been here. And so I do think that's a bit important.
And originally, and this is 50 years ago, the mayor's office was here. Everything was on the 3rd floor. We didn't have, and we had a matching twin building next door where the parking lot is at.
So you're telling me that the mayor wasn't on the 8th floor?
That building didn't exist. The mayor was here.
Oh,
But
okay.
I'm sorry, Councilman Maniscalco, would you like to be recognized?
Yeah.
What was about that chit chat?
All right. But I'm telling you, you know, how much does paint cost? You know, Charlie and I can go to Home Depot this weekend, and on a Sunday we could paint this room. I'm not being, we could, whatever, but I'm saying.
Mr. Maniscalco, are we having this discussion? Are we gonna move this to a workshop?
No, I'm just asking council members to reach out to Ms. Colina, and then she'll show you the renderings. You come to your own conclusion. I've shared my concerns. So that's that. No motion necessary.
Motion to receive and
No.
Oh.
And then one last thing is,
Councilman Maniscalco.
I just want to let council and the public know that we will be testing out the kiosk sign-in at next week's workshop meeting. The kiosk is not what you think. It's not huge. It's an iPad where you type in your name, it goes to the clerk, and then it gives me a list of who the speakers are. Very organized. I know council member Hertak brought it up. I saw I practiced on the technology yesterday. Mr. Shelby was there, Miss Edwards. It's not very complicated, but I just want to let you people know.
The cards?
No, this
This is just to test it out for the workshop.
Are you
and see how it
recognized?
works.
You were looking down.
Are you recognized?
I apologize.
Can I get a motion to receive and file?
Oh, I do have one more
Wait.
thing before you take that motion. before
Yes.
you adjourn.
Yes,
Just a
Mr. Chair.
reminder, council, that you had some things of significance today. If it's quasi judicial,
Discussed it.
you have an appeal period, you may be approached by those people who want to talk with you about it. I would advise against it. So please remain mindful
Of
that,
course.
do not speak to the public about anything that has a 30-day appeal period.
Thank you very much. Can I get a motion to receive and file?
We did that.
We have a motion and a second. All in favor? Aye. Any opposed? We're adjourned.
And I started fixing up the windows. I bought some tools, and I bought some bits and routers.